Good morning, everyone. I'm going to call the meeting to order. What's wrong? Okay. Beth, can we have a roll call, please?
Councilmember Burke.
Here.
Councilmember Wilkinson. Present. Mayor Cooper.
Here.
Councilmember Carapiet. Here. For the record, Councilmember Mark is absent.
Okay, thank you. So we only have one item on our agenda today under public hearing, and that's the appeal of construction time limit penalties imposed for the construction project located at 339 Golden Gate Avenue. Before we get into the main meeting, I just want to introduce the item to let everyone understand today's proceedings. The council takes each of these appeals very seriously. We study staff reports, read the appellant's appeal and supporting material, review prior meetings, the municipal code and the administrative policy manual, and attempt to understand legal arguments. We then listen to the information presented at this hearing prior to making a decision. The appeal hearing is a remand by Marin Superior Court Judge Sweet of an earlier hearing in July 2022. Given that none of the volunteer council members here are lawyers, we will do our best to meet the court's request. The normal proceedings are that following the council's question of staff after the staff report, the appellant has 10 minutes to present. However, I'm asking if the council will agree with me and allow Mr. Flaherty and his attorney to have a combined total of 20 minutes today instead of the 10. Assuming that's okay with everyone, the council will then ask questions. And then after that, the public has an opportunity to comment or ask questions. The public has 3 minutes, up to 3 minutes per person. Following this, the appellant will have, I'm suggesting and encouraging that we allow the appellant to have 10 minutes rather than the normal 5 minutes to add anything else. After that, I'll close the proceedings and the council will discuss and state our findings. I hope that's clear to everyone.
Let me ask you, Mr. Flaherty. If you're happy to, most people think that probably is
The thing is that the Zoom doesn't pick up unless it's on the microphone.
This button here? Yeah. Here, okay.
Perfect.
Madam Mayor, Council, this is a matter that's been going on for 8 years now. The litigation and appeal may be taking up the last 3.5. I believe right now the fine is probably up to around $400,000. This is a pretty serious matter. I would like to beg your patience to perhaps, I might need 30 minutes to present today.
Okay, would that include Mr. Flaherty? Is that 30 minutes total for this project?
Yes, I don't think Mr. Flaherty's going to have anything to say. It'll be mainly
okay.
be me
Okay.
trying to address things because there's an awful lot to cover here.
I
and I'm going
agree.
to try to do it as succinctly as I can, but it's a very serious matter, obviously.
Obviously, yes, we agree. I think that sounds fine to me. Does anyone have an objection? Okay, great. Thank you. Okay, with that, we will turn to the staff report.
Good morning, Mayor Cooper and council members. Thank you for taking the time to review the lengthy staff report and materials that were included in your packet. As you have spent a lot of time reviewing all the material, I'll provide a high-level summary of the project and Andrew Shen will provide some legal background. As Mayor Cooper mentioned, this item is a rehearing of construction time limit CTL penalties assessed to 339 Golden Gate Avenue under building permit number 2017-173. At its July 11th, 2022 hearing, the City Council denied the appeal of $300,000 penalty and affirm staff's recommendation to impose the fine for the violations of the city's CTL ordinance. On October 7th, 2022, Golden Gate Belvedere LLC filed a complaint with the Superior Court for Marin County challenging the city's CTL penalty. On May 27th, 2025, the court determined that the resolution adopted by the council in July 2022 did not adequately set forth findings regarding its denial of appeal and did not directly explain the basis for the council's decision. The court further emphasized the need for clear, detailed findings that explicate the city's decision and reasoning. As such, the court remanded the appeal to the city council with instructions that the council make further findings in support of its final decision of the appeal for the CTL penalty. On May 16th, 2017, the Planning Commission heard and approved the application for design review with an added condition of approval stating that the Planning Commission would review and approve the final landscape and lighting plan, which was approved by the Planning Commission on August 15th, 2017. On July 27th, 2017, the property owner submitted a building permit application. The initial submittal consisted of the remodel of the existing single-family home, along with demolition and reconstruction of the garage. The landscaping plan was a deferred submittal. On November 28th, 2017, the City Council approved and issued building permit number 2017-173, and per the governing CTL code that applied to the project and the $4 million project valuation, the project was subject to an 18-month construction time limit with an end date of May 28th, 2019. On May 28th, 2019, the CTL deadline elapsed without completion of the project. On the following day, the building department sent the 30-day CTL compliance order to the property owners, notifying them that the project was to be completed by June 29th, 2019, or penalties would be assessed. From May 5th, 2018 to February 21st, 2021, the applicant submitted an additional 10 planning applications that were reviewed and approved by city staff as either a design review exemption or design review exception, the majority of which were submitted after the original CTL deadline of May 28th, 2019. Most significantly, there was an approval in May of 2018 for a new swimming pool, new koi pond, spa, new driveway gates, and retaining walls. On August 23rd, 2019, the residence was inspected and deemed safe for habitation, and the city issued a temporary certificate of occupancy, or CTO. Per Belvedere Administrative Policy Manual, the issuance of the TCO in a remodel does not constitute a final building approval, final planning approval, nor end to the CTL fines. The signed CTO agreement also clarifies that a TCO does not end the CTL timeline. On June 21st, 2020, the property owner submitted an application for retroactive design review related to unapproved improvements, including landscaping and exterior lighting. On December 2nd, 2020, the building department conducted a final inspection and deemed the project final and complete for the purposes of the building department's requirements. Following the building department's finalization of the building permit, the property owner still needed to complete the project's landscaping and other steps required by the Planning Commission's August 18th, 2020 retroactive design review. On August 26, 2021, an easement agreement was signed between the Flahertys and the city, granting a utility easement and allowing the olive trees to be maintained at a height of no greater than 16 feet. This agreement also notes the city's rights to impose construction time limit penalties. On March 21st, 2022, the remaining work was completed, inspected, and approved by the Planning Department, ending the CTL timeline. The CTL was appealed and heard by the council in May of 2022. The council denied that appeal. The maximum CTL penalty of $300,000 was reached on November 23rd, 2020. This calculation includes the full 60-day extension for the North Bay fire, the customary 30-day grace period, the 90-day extension for landscaping, 34 days of COVID relief as directed by Marin County, plus an additional 30 days of mobilization relief specifically added to Belvedere's associated urgency ordinance. This is a total of 244 days of construction time limit extensions. Completion of 339 Golden Gate Avenue project took 4.5 years, including many delays resulting from the property owner's multiple planning applications during the course of the project. And with that, I will hand it over to Andrew Shen.
Good morning, Mayor. Good morning, Council. Andrew Shen, City Attorney. Thank you, Rebecca, for kicking off our presentation. I do just want to note for the record that the easement agreement, that October 2021 easement agreement that Rebecca mentioned, a copy of that agreement has been provided to you, Council, and copies are available on the dais. Copies have also been provided to Mr. O'Connor, Mr. Flaherty. So I do just want to provide, just touch on a few issues for you this morning. Like Rebecca, I fully acknowledge that you've spent a lot of time already reviewing the materials. So I won't attempt to cover all the issues, but I did just want to cover a few before we get it to your questions. So the first issue that I just want to address at the outset is the potential application of Assembly Bill 1561. I imagine that will come up during further questioning of both us and Mr. Flaherty and Mr. O'Connor later this morning. AB 1561 was enacted on September 28, 2020, with the intent of providing a uniform statewide entitlement extension for certain housing development projects impacted by pandemic-related issues. The legislation provided an 18-month extension for certain housing entitlements that existed as of March 4th, 2020. However, as set forth in the staff report, it is staff's position that the project does not qualify for this extension. It does not qualify for the extension for two reasons. The first is that it is not a housing development project as defined in the statute. The legislature's intent in enacting AB 5061 was to assist the housing industry and meet the state's concurrent housing crisis. Given this intent on additional housing units and additional housing developments, quite simply, a single family home remodel such as 339 does not add housing, does not fall within the definition of a housing development project for the purposes of this law. The project simply sought to enlarge an existing single-family dwelling and did not add to the housing stock in Belvedere. Further, as a second reason why AB 1561 does not apply to this project, the permit was not open or in effect as of March 4th, 2020, as required by the statute. The extension only applies to a housing entitlement that was issued prior to and was in effect as of March 4th, 2020. But since the project had already exceeded the adjusted CTL end date of November 25th, 2019, the project had already violated a term of its building permit and prior conditions of approval and should not be considered in effect as of that date. I should also note that we do acknowledge that city staff provided prior incorrect notification to the property owner applicant about whether the project qualifies for the AB 1561 extension. But for the reasons set forth in our staff report, this shift in position and this correction does not legally bind the city. It doesn't bind the city for several reasons, one of which is that normally such estoppel or binding statements made on behalf of the city do not usually bind government officials as a general matter. But most importantly, as a practical matter, there should have been no reliance on this notification. As Rebecca already mentioned, the project should have been completed by May of 2019, long before AB 1561 came into existence, and long before anyone from the city would have notified the applicant about any potential application of the statute to the project as well. Certainly, there would have been no reason to believe at that point when they were working on the project and hopefully trying to achieve completion by the May 2019 date, that there'd be some extension like this in the offing. May 2019, I should remind the council, was long before any of us heard of anything along the lines of COVID or any pandemic. I want to touch on a second issue that both sides have addressed here, and that is the issue of excessive fines under the Eighth Amendment. For the reasons set forth in the staff report, the proposed CTL penalty does not violate the principle of proportionality required by this constitutional rule. The analysis of this issue requires an examination of 4 factors, and I'll just briefly review those very quickly. The 4 factors are culpability, relationship between the harm and the penalty, penalties imposed in similar statutes, and ability to pay. The staff report does provide further analysis of these factors, but I do just want to briefly summarize how we concluded they should apply to this project. First, in terms of culpability, the applicant is culpable for his failure to comply with the CTL deadline. Courts assessing whether a fine is constitutionally excessive have held that a party is culpable when it demonstrates an unwillingness to comply with the law. As described in more detail in the staff report, staff and city took great pains to inform the applicant and property owner of what the deadline was and what the deadline requires and when the deadline would expire. Nonetheless, as explained by Rebecca, they obviously went long past the CTL end date. And as set forth in more detail by Rebecca, they continue to apply for approvals and permits and other permissions long after the CTL end date had passed. In terms of the second factor regarding the relationship between the harm and the penalty, this city council is well aware of the important public policy reasons that the CTL ordinance exists. The CTL ordinance exists to protect the community in Belvedere. It protects to avoid adverse impacts on the city and its residents from construction activities, such as construction trucks blocking streets, potentially blocking emergency vehicles, long-term noise disturbances, and frequent closures of city streets for other reasons. Those are the types of harms that the CTL ordinance is enacted for and what is intended to prevent. Third, in terms of the penalties imposed in similar statutes, I will just note, without listing them all, that the staff reports list several cases, several opinions issued by the California Court of Appeal upholding more significant penalties than the one the council is considered today. Some of these penalties are well into the 6 figures. Some of these penalties are well into the 7 figures. I will also note, I won't list them all, but the staff report does list them in some detail, that there are several other Bay Area communities and cities that impose daily penalties similar to those imposed by Belvedere. Those penalties similarly provide for daily penalties up to $800 or $1,000 per day. In terms of the fourth factor, ability to pay, I just want to briefly touch on the fact that we should consider the penalty in light of the value of the property in question. According to publicly available property listings, the current estimated value of 339 is between 10 and approximately $16 million. Using the low range of these estimates, $10 million, the proposed $300,000 penalty is less than 3% of the current estimated value of the property. That, I think, bears significantly on considering the applicant's ability to pay the proposed penalty. And the third issue that sorry, there's a little delay in the slides there. The third issue that I just briefly want to talk about, because I think this is also an issue that we'll probably spend some time discussing this morning, is how the CTL ordinance operates. The first thing I do want to emphasize, and I don't think the applicant really takes issue with this, but we'll certainly see, is that at the outset, as I already previously mentioned, staff took many measures and took many steps to ensure that the CTL end date was well communicated to the applicant at the outset of this project. The time limit was set forth in the initial Planning Commission resolution providing the first design review approval. The CTL time limit was also provided, again, at the pre-construction meeting that our building official routinely holds with all project owners and the project team. The CTL time limit was also set forth on the permit. It was also set forth on the plan. We're almost there. Okay, last slide. I also want to say that the operation of the CTL ordinance is quite simple in its application and concept. I think we'll hear a lot of sort of feigned confusion about how the CTL ordinance operates or what it actually requires of the applicant, but it's frankly quite simple. The CTL ordinance begins by establishing a time limit, as I already mentioned, that was well communicated to the applicant and owner. Once that date is communicated, that is the deadline for when the project is complete or should be complete. And when it is complete is when the project receives final building and planning approvals. This provides a clear, bright line for all parties involved, the city, the contractors, the owners, about when the project must be done. It is simply a matter of them calling City Hall, asking us and our staff to come out and inspect the property and provide final sign-off. That is what stops the clock in terms of the CTL deadline. It is the property owner's duty It is the property owner's obligation to make that phone call and make sure that final inspection happens. Now, the reason why this works in practice is that obviously our staff cannot be on site on any given project, checking on a daily basis about what is happening on a given day. We have to look to the property owner to let us know when the project is ready. And certainly when the project is ready and we get the phone call, we report out to the site as quickly as possible. I also want to note, and this is in the staff report as well, that the applicant himself acknowledged this is how the CTL ordinance works. It is included as attachment 12. Rebecca had already alluded to this agreement that Mr. Flaherty signed that indicates that he clearly understood that, again, the time the clock stops running when the project receives final building and planning approval. So there certainly should have been no mystery to how the ordinance operates way back when the project started or when subsequent approvals were provided by the building inspection team or as discussed during today's hearing. Thank you very much. And then I think Rebecca and I would be happy to answer your questions.
Okay, thank you. Then in that case, I'm going to bring it back to council and we will begin asking questions of the staff. Can I ask Councilmember Carapiet to start, please?
Thank you very much for all of that information. Very helpful. One question I have is that through time, the CTL extension process, when it's granted, has changed. Can you just clarify, and this is for whoever in staff feels they should answer, can you clarify what the process was in 2017?
Under that governing CTL code, the only time a project or an applicant could obtain an extension was prior to the issuance of the building permit. Once the building permit was issued, that option was no longer available.
And did you provide that option during your construction management meeting in your discussion with the applicant and contractor?
Yes, sir.
And what was the response by the applicant when you offered that?
That they could get it done in 18 months.
Okay, thank you. And then one question I have is throughout, well, not throughout, but in the staff report, you talk about a final landscape plan on 8/15/2017, which I think was what went to the Planning Commission, and a deferred landscape plan of 8/30/2018. Can you just explain what the difference between a final landscape and a deferred landscape plan?
Sure. When we were talking about the deferred landscape plan, it was a deferred submittal for the building permit. So the initial building permit did not include the landscaping plan.
Okay, thank you. And this goes on to in 2019, when the temporary certificate of occupancy was given. The temporary certificate of occupancy, my understanding is done basically for interior health and safety issues. That it's safe and healthy for somebody to live in the house. That all things may not be done, but there's certain elements that are complete. Is that correct?
It would be not just interior, but all life safety aspects of the project. So there could be deck guardrails, things like that, that would be required that we would not sign off until the property was safe.
So the entire property was safe, both inside and outside?
Correct.
Okay. But that doesn't mean that all the work was complete. Is that correct?
That is correct.
Thank you. And then my next question is try to be concise on this. So are exterior light fixtures that are attached to the building under building department review?
Yes, they are. However, in going back to the context of your last question, Some light fixtures may be life safety issues, such as one at doors. Other light fixtures may not be. And the pure installation of the light fixture itself would not be part of the inspection. We would look at the rough wiring through the building, as well as the box the fixture would be connected to. But following that, we would not inspect the finished fixture and pull it off the wall.
Oh, okay. Okay, great. Do you know, has the part of the CTL, the list on 14.4.2, the administrative policy, states that the building has to have received its reevaluation for the building permit? Do you know if that took place?
I do not recall off the top of my head if we received the revaluation package or not for this.
Okay. And then the next question is approved landscaping, plants, trees, etc., are part of the CTL, I'll call it exclusion for landscaping. Is that correct?
I believe you're referring to the 90-day landscape extension.
Thank you.
That extension covers three main items really for the extension, and that is the installation of plants, the installation of drip irrigation, and ground cover.
And would it include unapproved landscaping, plants, ground cover?
It could, if there was unapproved landscaping and the plan was to remedy it during that 90 days, perhaps it could.
What, if I could add, if you don't mind, Rebecca, thank you. So as you highlighted, Councilmember Carapiet, that sort of, I guess what we're referring to as an exclusion explicitly refers only to approved plant materials and trees.
Correct.
And does not bless unapproved plant materials and trees.
Okay,
Thank you.
thank you. And so just to follow up on that question, that would include any outstanding planning commission design review resolutions with conditions to be resolved.
That is correct, council member.
Okay.
Certainly to receive final planning approval, and I'll certainly defer to Rebecca if she has more to add here. To receive final planning approval, the project in question must apply with all conditions imposed by a planning commission or the city otherwise. Certainly it would be somewhat nonsensical if someone could build a completely unapproved project and somehow still satisfy the CTL ordinance.
Okay, and then just to clarify, crystal clear here,
Sure.
sorry. Things that are not included in the landscape extension or not to be considered part of a project to be considered complete are patios, arbors, and trellises and other elements.
Correct.
Okay, thank you. There's talk in the staff report and also in a reason from the applicant that there was an unknown retaining wall, underground retaining wall that needed to be done that caused some issues. And in the project, it describes several retaining walls. But this unknown retaining wall, it's a bit unclear. Where was it located and when was it discovered? Because it was unknown and it was discovered when they were doing landscaping, according to the reports.
I don't have a specific date of when exactly the wall was discovered. The location, if you are looking at the house or at the residence with Golden Gate behind you, I believe the wall they're referring to is on the left-hand side of the residence, helping support the kind of roundabout driveway or auto court that they have there.
Okay, thank you.
Can I jump in and just do a follow-up?
Sure,
quick
sure, yeah,
question?
please.
So on that same wall, what was this, because it was unknown, I'm assuming it wasn't authorized by the planning commission or planning department until you knew about it? Is that how that works? And so did this become another retroactive permit, or how, when something is discovered, were you told about it right away, or was work commenced on it?
Yes, I'm gonna pass this to Brian since he was more involved with the
Okay.
project at that time.
The property owner or the contractor did alert us to the wall being obviously in place, and some revisions at that point were submitted. If I recall correctly, it was a long time ago. But revisions were submitted to help support or reinforce the wall, with some sections being reconstructed, if I recall correctly.
And would that have caused a delay in the project? For any reason? Did it just sort of happen and then it kept going, or was it?
The
Did it have
project
to
kept
come back?
moving along. We did not stop the project
Okay.
due to that wall.
Okay,
Revisions were submitted and work just kept going as we reviewed the revisions and the structural necessities to help reinforce that wall.
okay, thanks, sorry.
No, that's okay, that's perfect. Better than going back and forth all the time. So can you clarify how what the city process is when you establish a CTL date for every project? And then do you keep a running tab on credits that people might should receive that would make you change everybody's CTL date as you went along? Or do you just use that CTL date as our CTL date? And then when the project's all done, you sit down and figure out what particularly happened within that particular project, just as a general policy?
So there is no automatic relief as per the governing code. The CTL starts the date of the issuance of the building permit, and then you are allotted your amount of time for completion. There are no stoppages of the clock. There are no additions to the clock. Your avenue for remedy of any type of penalty or fines is at the end of the project, where you can appeal said fines. And then you can, there's a list of approvable findings in the, I believe it's F5 of that code section, that list what are acceptable reasons for project delays. At no time is anyone given an automatic extension, or is that date moved. It is set in stone once we issue the permit.
Okay, so we shouldn't anticipate that once the CTL date is set, and then they get their 30 days, whatever that date is, that's the date that you deal with. You don't make adjustments as you go along
No.
until the whole thing is finished, and then they come back in and you deal
Those are
with
the
it
working
individually.
dates, yes.
Okay,
And then
all right.
per the code, we send the 30-day grace period letter following the completion of the CTL date.
Perfect. And then recently there was some information that I believe after the building final on December 2nd, 2020, that there was some driveway resurfacing or change in the surfacing.
We don't have records in the building department files, but from what I recall is there was a change in material from asphalt driveway to decomposed granite, or DG. driveway, and that is in that auto corridor roundabout on the property.
Okay.
But the building department would not record a change such as that. It is not required to have a building permit for that scope of work.
Okay, all right, great. So, and then just to touch just a tad on the AB 52, excuse me, 1561. Just to confirm that 339 Golden Gate did not add any additional units during their project.
No, there are 2 units out there. However, both units existed prior to the issuance of this building permit.
Okay. Oh, and then just as point of clarification or knowledge, when the planning department goes out to do their final, do you have a form you use, or is it more that you look at what the plans were and make sure that what's there conforms to what the plans were, plus any changes that might have come through?
We bring the plans with us to verify all the lighting, all the windows are in place, all the landscaping. Oftentimes we'll count plants, count lights. So we don't necessarily have a form. And should there have been any further design review exemptions or exceptions, we bring that paperwork with us up to the final.
Okay. All right. I think so far that's my questions.
Okay, thank you. Councilmember Burke, would you like to go?
I don't have any questions. I
Okay,
felt it was very comprehensive. Thank
great.
you.
Councilmember Wilkinson.
Thank you. I have just a few to ask, but many of my questions were clarified by Pat, so thank you for that. The first question I have is in relation to the TCO. Is that always the case that that's part of the process? Do all houses get that?
No, not necessarily. Usually, per the building code, your occupancy is not stripped in a remodel. You may not have all habitational requirements as set forth by the health and safety code, but per the building code, your occupancy would not be stripped. We do offer temporary certificates of occupancy and things like that on occasion. A lot of times it's financial purposes for the applicant or the property owner to close out loans or things like that. So we have no issue with if everything is safe and occupying the building will not create a life safety issue for anyone, then the building department really has no issue with issuing a temporary certificate of occupancy.
Okay, but that in no way suggests that construction is anywhere close to completion. And following on from that, can you just explain some of the activity that was still to take place after that TCO was issued?
Following the TCO, yes. So following that would have been mostly finish aesthetic material, like such as painting, things like that. We did have some issues at a later date prior to the building final sign off, where there appeared to be elements in the project that were added without approval, such as lighting and things like that, that we had to then come out and verify some of these circuits were permanently disconnected, or the applicant was then working with the planning department to have these elements approved. In between, I would guess you would say there would be landscaping being done. Again, finish, like what we call punch item list painting, touch-up paint, things like that. Could flat work, such as sidewalks, not part of the means of egress. And if I recall correctly, much of the front area planting and finished material had to be installed, such as like wall caps and things like that on the front.
So these are still activities that require significant parking and impacts to the community.
Correct, yes.
Okay, thank you. The next question I had was in relation to our CTL ordinance at the time and the number of days in this project in total. So at the time, we had a 300,000 limit cap on our CTL fine, and that's 290. You hit that ceiling after 295 days, correct?
Yes, per my calculation, yeah.
Okay, so if we, your recommendation is that there's 244 days of relief, but this project took 4.5 years. So by how many days in total were they over? So if we're saying it takes 295 to hit the ceiling, how many days in aggregate were they over? I'm sorry to put you on the spot there.
I believe we have down 300 days. I don't have the calculation right in front of me. Go through the staff report here. We have that at the
Are you
end.
asking for
Well, it sounds, I mean,
planning?
it sounds like the project,
Planning file or building file?
the project was about 4.5 years in duration, correct? From when the permit was issued to when the planning final was. So that's roughly 3 years over. We gave roughly 8 months, or you're suggesting 8 months of relief. So that's still 2 years and 4 months. Does that sound about right? I'm trying to.
We got a total of 300 days.
I'll work on the math if you want.
Okay,
Keep going.
I'm just trying to ascertain, if this was 600 days over and we hit the ceiling after 295 days, I'm trying to get an idea of that in terms of the scale, because obviously there's different factors at play here, and it would just be good to know that number. But I'm sorry to put you on the spot there.
I believe we were over 300 days still with.
Even after the.
Correct.
Okay.
Yes.
Okay, that makes sense. The next question I had was in relation to AB 1561. So that came into effect September 28th, 2020. Or that was when that was passed by the state. When did we send the initial letter to the applicant saying that they qualified for that?
I don't believe that was a written letter. I believe that was a verbal conversation between the planning and building, a verbal conversation between the planning and building director and the property owner. The letter we sent out later would be the letter notifying the property owner that they did not qualify for that extension.
So how do we know that verbal conversation, that was prior staff, correct?
Yes, ma'am.
So there was a verbal conversation, and then it took a number of months after that to send the letter saying that, in fact, the property didn't qualify because it didn't meet the state criteria.
Yes, ma'am.
And that gap was because of uncertainty around the legislation. Was that a time when all cities were trying to figure out its meaning, or?
Yes, it was immediately following the pandemic, the COVID-19 pandemic. This bill came out from the state. It also took the state a while to provide relief after COVID to produce this bill. And there was just much uncertainty on how it should be applied. There was not a lot of definitions provided and guidance provided by the state on how individual municipalities should apply this assembly bill. It was new to everyone at that point.
So once the legislation was clarified, you guys did the work to ascertain whether properties qualified or not, and you informed the property owner that they were not eligible under the more precise state guidance.
Yes, ma'am.
Okay, thank you.
Okay. Can you recall if both homeowners and the contractor attended a pre-construction meeting?
Per our record, the contractor was there as long as Mrs. Flaherty.
Okay, so Mr. Flaherty was not at the meeting.
Correct, per our records.
Okay, so you also stated that he determined that he didn't need the 6-month extension on the remodel. But when would you have had that conversation with him if he wasn't there?
That conversation was had at the pre-construction meeting. Also, we would have had that conversation just in passing or in talks about the project. Staff spends a lot of time conversing with property owners, contractors, just over the phone informally. And
Okay.
again, this is not one of those things that we like to keep secret. We want to make sure that everyone is aware of this code and of these timelines, because again, the intent of this is to have the project completed as soon as possible.
So even though he didn't attend the formal pre-construction meeting, one of the owners did and the contractor did, and this was presented at that time. Okay. And again, if Mr. Flaherty didn't attend the meeting, when did he put in the requests for the 90-day landscape extension?
I don't have anything written. He worked very closely with Irene Borba, the former planning director, and I re-listened to that pre-construction meeting and it was discussed then. So he had placed, there's a deposit for it, so we had the deposit. So at some
okay.
point there was a conversation about it.
Okay, great, thanks. Can you clarify for me where in the municipal code the construction time limit is located? I think is it correct that it's under design review and not under building and construction? So
That is correct. The governing code for this project would be municipal code 20.04.035.
and building and construction codes start with a 16, I think?
Yes, ma'am.
Okay. So is it safe for me to assume then that the term construction in the construction time limit actually covers policies governed under both design review and building, not simply hammer and nails?
That is correct. Yes, ma'am.
So that a normal person would think of construction like this, but because it comes under design review, it would be subject to those policies.
It's seen more as a project and a scope of work for a project, not necessarily just once the building is framed or anything like that, then the project is complete. The project is seen as a whole, including landscaping, painting, and all elements that may or may not be subject to a building permit.
Okay. Let's see, I had questions about all these deferred landscape plans too, but I think you answered those. Can you explain what a retroactive design review means? How does it happen?
Sure. So if you have a project that went to planning commission, has a building permit, either Gennaro goes out and does an inspection or staff needs to come out or planning staff needs to come out for another reason, and it's visible that a change was made in the project, an exterior change or a landscaping change was made that does not comply with the approved plans at planning commission or building permit. At that point, we would and say the scope of work requires design review. At that point, we would call it a retroactive design review and decide either it raises to the level of planning commission or it can be a design review exception, or in some cases, if it doesn't require design review, then it's an exemption. So then we would go through that process. Typically, projects aren't stopped for it because there's a lot of other aspects of these large projects that can continue on. However, sometimes they are. And so we would run through the process of design review.
Okay, so although the project didn't get stopped, would this be something that could be considered a delay because of having to come back, in this case, to the actual planning commission? And so that it would require different plans, require more work, rather than had it just come originally?
Yeah, so for the reasons explained by Rebecca, those retroactive design review requests wouldn't necessarily create any delays
Oh,
because other
okay.
aspects of the project can continue. But I would also just say, the term retroactive, is sort of an after the fact permission for some aspect of the project to be approved.
Okay,
And for the reasons that Rebecca explained, it's sort of a second or third consideration of the project. Certainly, we would hope that most project applications and project owners have everything sort of set and planned and have sort of thought all the things through from the outset, rather than having to go into planning commission multiple times for the same project. Certainly, we hope that things are already in place and again, the project can move smoothly for the most
Okay.
part.
I did forget to ask Brian one question. Are landscape lights different from exterior lights on a home?
Yes, possibly. They could be, normally, homes attached to a structure are designed, listed, and tested for that use, as would be the landscape lighting as well. Occasionally, they can be interchangeable possibly.
Well, in our code, it says something about non-CTL landscape lighting, but then non-CTL causing. But then in another section, it says CTL causing lighting. So I'm trying to understand the difference between those two.
It seems like it would be the installation method, lighting that is hardwired through conduit powered by
Oh,
the
okay.
building. The panels itself would be under building department review, things like that. Solar lighting you can buy at Home Depot and you get a pack of 18 of them in a box and then stick them in the ground and you have porch or path lighting. No, not necessarily.
Okay, great. Thanks. In the planning section where you can check on the permits, I counted 28 separate permits for concrete pouring. Is each permit a separate item and a new delivery?
I believe you're referring to the encroachment permits and or the road closures.
Yeah,
And for concrete pours, you are allowed as many trucks as you can get in the time frame under one permit. So I think it would be safe to assume that each one of those encroachment permits for a concrete pour was a separate pour.
separate pour.
Correct.
Okay, that's what I.
With possibly numerous trucks on for
With-
each one.
Right, concrete trucks, then going to the property and leaving the property and coming back through the city 2 different ways. They don't
Correct.
just hang out there.
No, we do not
Okay.
allow trucks to position themselves within city limits.
Okay.
There would be most likely a pump at the least, if not a pump crane, depending. Okay. no
I just wanted to know if they were different. I don't need to know how they happen. I'm not a 5-year-old boy. It's not of interest to me. Okay. When I was reading AB 1561, I noted that there was actually a secondary set of requirements, which included an approved tentative map or vesting tentative map, a mixed-use development, or a residential development. I'm assuming that this remodel did not have a tentative map or vesting map, which I think have to do with subdivision. And as far as I know, there's no commercial aspect of it, so it's not mixed use.
That's correct. It would not
Okay.
qualify under either
So
of
it
those terms
wouldn't
either.
qualify for any of that either.
That's correct, Mayor.
Okay,
Would not qualify under those other prongs.
okay. Sorry, this is taking so long, but as we all said, it is complicated. Does the building department do inspections on a regular basis, or is there a process for when you go inspect?
There is kind of a loose process. The rule of thumb is don't cover anything without us looking at it. However, we rely on normally the contractor and or the property owner to call us out to inspect and review the work that was installed or constructed.
So you
So
don't
we-
just drop in?
Not unless we receive a complaint
Okay.
from a neighbor or something
Oh,
like that.
okay.
But to inspect the work, no, we don't just pop in.
Okay. I think you went over our process of how we do the permitting, and once the whole project is signed off by planning, then there's the opportunity for the homeowner to meet with a appeal committee and present reasons that they feel should eliminate some of the penalty fees or give relief days. And I'm assuming that happened in this case. And then after that, that committee makes a recommendation to the city council. And that happened at the July 2022 hearing.
Yes, ma'am.
And that was when all the relief days came into play. And
Yes,
okay.
ma'am.
According to my calculations, I know you were using the time that the CTL penalty was finished in November, but to go along with our process, before it went to city council in July, would you say that the actual date when any penalty ended was April 28th, 2020?
No.
Pre-relief days?
No, the CTL ended May 28th, 2019. It's clear when we're issuing a building permit, they have a 30-day grace period, right? So then we issued the 30-day CTL compliance order, and that all construction and sign-offs needed to happen by June 29th, 2019.
Right. And
Right.
then it took 10 months to reach 300,000. And that takes you to April 2020 with no relief days given. So the actual date when the penalty reached 300,000 is April 2020, not November.
I haven't done that math,
Okay,
and I
I
can't do
did.
it in my head.
I'm
so-
just clarifying it. Okay. So I guess what I'm trying to get at is, were any other penalties accruing after April 28th, 2020 through to March when it was finalized March 2022?
That sounds correct based
Okay.
on your math, yes.
Okay.
Because it's capped at 300,000.
Okay.
Once the project hit the cap, there are no other additional penalties that are
Nothing
assessed.
else was added on?
Correct.
Okay. Okay, I'm done. Thank you.
I actually have a couple more questions, sorry. I'll
Yeah,
try
and
to-
I have one point of clarification.
Okay.
Oh,
No, I want to go back to AB 1561 just because there were questions about the timing and that conversation. I think the assertion is that it happened in October, and there was an email from Mr. Flaherty to the city, I think it was November 4th of 2020, saying that he was grateful that AB 1561 applied. Was there ever any dispute or response to that email? I didn't see anything in the record that said, no, that's a misunderstanding, or you're not recalling that conversation correctly?
Yeah, I don't believe we're aware of any other emails on that point.
Okay.
I did see that November 4th email among the documents that Mr. O'Connor submitted. But I don't believe there's anyone from the city end of things who said the same, if I remember that email back and forth.
I'm sorry, say that again?
So sure, I remember there was an email from
Yeah.
Mr. Flaherty that said, thank you regarding the extension. But I don't believe there's anyone from the city who subsequently confirmed the same. if I
No,
remember.
not in writing, not in the email.
Not in that email,
responding to
Jim.
that. I was asking if anyone responded to that email that you know of.
No, we're not
Okay.
aware of any other responses.
So we
Thank
can
you.
assume that it probably happened around that date. And then, of course, the revision was sent via letter in writing August 21st, 2021. Thank you.
Okay, so a few more questions. Just to confirm that does the city send out a separate CTL compliance letter regarding landscaping and/or the planning final?
No.
Okay, and then regarding weather, has there been any discovery that there were any major weather events in November 2018 to March 19th that has been discovered since your appeal hearing?
No new information in that context has been provided
Okay.
or discovered.
And the appellant has stated that there was appeals and complaints that caused delays. The only appeal I know of during the early process or during construction, the only appeal was the original appeal to the August 2017 Planning Commission approval of the project. Was there any other appeals that caused any delays?
If I'm remembering correctly, there was one other appeal, yes. It was the original design review appeal. And then the second appeal was the landscaping plan heard by the council 3 months later on September 11th, 2017.
Okay, so it was all before construction started.
Yes.
Okay,
Yeah,
that was my question.
yeah,
I
that's
guess.
correct, council member. So those would have occurred before any building permit was issued.
Right.
Or the CTL began.
Right, correct. Okay, thank you. And then complaints are normal. But were there any complaints that caused any delay during the construction time?
Not necessarily delay. We receive complaints on a majority of projects that we have within the city. Most of the time, the complaint is valid. However, we would just go talk to the property owner and or contractor to remedy the issue at that point. Many of the complaints were self-inflicted for this project and revolved around parking and excessive parking.
Okay, thank you. There's conversation regarding interference by the city around the, I'm going to combine these a little bit, around the lane construction, the new Golden Gate lane construction, and also the Golden Gate undergrounding project, that those two projects interfered with the construction of 339 Golden Gate. Are you aware of any particular instances where there were direct impacts on 339 Golden Gate from those city projects?
No, I am not aware of any.
And then my last question is, many citizens in this community, so a little bit of a statement, but many citizens in this community give to the community on very many levels, whether it's their time, their expertise, they're donating money, their whatever, to make this a better place to live. Do you know of any other circumstances where a community member who gave, I will say, of themselves under any of those circumstances, where they were given any kind of special privilege or consideration by the city pertaining to a construction or a personal project that was being done?
Not that I'm aware of. The building department does not concern itself with the private actions or the donations or the charitable actions of a citizen. The code is written, it is black and white. That is what we enforce.
Okay. And then I guess, Mr. Zanuck, do you know of any special circumstances that have been granted by the city for someone who gave of their time, expertise, and or monetary contribution to make the community better?
Not in my experience with the city.
Thank you. That's my last question.
Okay, I know this has gone on for a while, so I'm going to request a 5-minute break so people can stand up, and we have bathroom facilities out in the hall if anybody needs it. I'm going to reconvene the meeting after the break. And I'm going to open this up to public hearing and invite up the appellant or representative of the appellant. And as we discussed, you have 30 minutes for your presentation.
All right, is this on? This
Yes.
is on, okay, good. All right, let me do some housekeeping. First, did everyone get my little handout? And can the record reflect, can this be part of the administrative record? Most of it is already in the record already. These are excerpts. The only thing that is added is a declaration of Mr. Stuart Emery, and I'll tell you where that is. Number 11, there's a Stuart Emery declaration in there. And number 6, there's a November 21, 25 email string enclosing an email from Calvin Craig, who is a contractor on this. Other than those 2 additions, everything in here is in the administrative record already. All right.
Can I ask our attorney if that allowed?
Yes, that would be appropriate. Any material submitted for this hearing or in advance of the hearing will be incorporated in the administrative record.
Okay, great. Thank you.
So I have a question too. So there's a declaration here that none of us have seen. Do we get time to read this so we know what you're talking about and we know how to analyze it and have questions?
Sure,
if we
I'll
do?
refer to it. You don't need to really, I mean, I'll get to it and then you can,
Okay,
yeah. Basically, Stuart Emery simply says he had a conversation with Craig Middleton, several conversations when there was a dispute between Mr. Flaherty and Mr. Mark about removing the trees, and Mr. Flaherty wishing to remove any problems with finaling this project. So what happened was Mr. Mark and the Planning Commission had ordered Mr. Flaherty to remove the trees. The city wanted an undergrounding easement over its property, over Mr. Flaherty's property. Mr. Flaherty had proposed to trade the undergrounding easement and remove Mr. Mark's contention that Mr. Flaherty owed CTL fines. Mr. Flaherty always contended he did not owe CTL fines, but Mr. Mark was contending he owed CTL fines because he did not remove the trees. So one of the issues I'm going to come up to later is, can you get CTL fines because you don't remove trees? You have presumably defied an order, but the trees have been existing. The trees have been existing since February 4th, 2020, but they continue to exist. Now, at page 1597 of the administrative record, and also in the settlement agreement that was reached on the undergrounding easement with Ms. Longfellow correctly talks about the real remedies that should have been pursued to get rid of, to punish Mr. Flaherty for not removing the trees. Now, eventually, as you know, the trees were allowed to remain. But during the time he did not remove them, what is the sanction? On the record in the Planning Commission, Mr. Mark asked Ms. Longfellow, what do we do when someone doesn't obey a Planning Commission order? And this had to do with the variety of things, including the trees, including lights. What happens if you don't do the lighting that we ask? And Ms. Longfellow correctly said, well, and I'll quote just about, you can issue an administrative citation, like a ticket, she says, so much a day, or you can do a code enforcement action. Fine. Now, for code enforcement, I think you can go in and you can ask a judge to order the order to be followed, but you also can enforce it at $1,000 a day. I think in Belvedere, I think that limit is 100 days. So the correct remedy here would have been to try to get $100,000 from Mr. Flaherty for 100 days of not removing the trees. All right. He didn't remove the trees, but that remedy was not pursued. Now we settle the matter, and those remedies are waived by the city. And the only remedy that is left is CTL fines. And what we say is, it's not CTL if a tree is sitting in the ground. This tree was sitting in the ground from February 4th, 2020, and you'll see that's just, by the way, just about the time limits ran out. If that's construction, if you can say, well, we consider that tree construction because after all, it was unapproved. We'll consider that construction, even though normally plantings are not considered construction. Normally, if you plant your petunias, you can't get CTL fines for planting them 15 days or 80 days after the time limits. That's in the law. That's considered pure landscaping, and fines do not run for pure landscaping. And I'll show you that site. There are two laws, the city laws, Administrative Code 14.4.2 and City Policy Number 30206. Both are identical, and they both say you can't run fines for pure landscaping. So if you go out after your time is up and you do the things you're supposed to, you put in a sprinkler system, and I think Mayor Cooper mentioned some of the things that don't draw fines. Lighting, they talk about landscaping lighting, things like that. Irrigation, sprinklers, those don't run fines even if they occur after the date. What you care about, and that's what both the laws I cited talk about, is when do you stop the CTL time running? Even though the file may be open, that doesn't control things. The file may be open, but these laws tell you when, for CTL purposes, things stop. Now, I've cited those. I've cited those in my presentation. Actually, it's number 1 in the folder, and you'll see that. Number 1 tells you the policies that building and planning have come up with. And I believe on the first page that is highlighted, this is a remodel, of course, and it says here under 2004035, it says in the first page there that's highlighted, a remodel shall be deemed completed for purpose of this section upon final building inspection approval. In this case, final building inspection approval was December 2, 2020. But before then you get into, if you go to the next page, it talks about, well, even before approvals, when does this TTL time stop? And building had meetings, and it talks about it in the second page I talked to you about here. We had a series of meetings, building did, for the specific purpose of developing the criteria by which a project was considered complete to the degree that it should no longer be subject to construction time limits. Those words I just read to you are the crux of this case. All right, now, it goes on. The next page talks about construction. It describes some things that are construction that you run fines for. And the page after that, which is 14-16, talks about, and I think Mayor Cooper asked about this, project elements considered landscaping and not subject to CTL final approval. And there we get into lighting and irrigation. Now, unspoken in all this is this notion. If you can have activity that's landscaping, and you can have activity that's construction, including construction within the landscaping scope, koi ponds, retaining walls, things that the Flaherty's did here. They did construction within the landscaping scope timely, but they did it. So just because it's landscaping doesn't mean it's not CTL. There's CTL, but in this case, Flaherty did all that timely. So now, unspoken in all this, that seems obvious, is that if you're doing nothing, you've quit your landscaping, you've quit your building, you're doing nothing except perhaps having some, as we had here, some retroactive design approval meetings. If you're doing nothing can the CTL time run? Our case is that we did nothing after March 20 or so, 2020. In Mr. Flaherty's declaration at paragraph 19, he talks about, and we refer to Mr. Calvin Craig's email confirming Mr. Flaherty's statement that the last thing he did on the project was in around March 20, 2020, 2 years before this thing was final. 2 years is the last thing he did on this project. It is provable. We have the documents, and there is no other record. I've enclosed all the records. There's no record of him having done anything else after March of 2020. So now the question is, why did it take 2 years to final this? So the issue for you to decide, and for the court to decide if it comes to this, if you affirm this fine, is it okay to issue a fine because Mr. Mark and Mr. Flaherty have an Irish standoff on whether to remove the trees? Is the existence of a tree construction, or is it what Ms. Longfellow said should be remedied in some other way? You have not done what Mr. Mark in planning wanted. The way you should do this thing is to actually follow the code. You either ticket Mr. Flaherty or you go to court, or you don't. You don't get CTL for it. That's the thing. Now, Ms. Borba, and we've enclosed this, Ms. Borba says, it is very clear, and it has been clear, that she can't final this matter as long as there's this planning condition approval out there. In other words, as long as Mr. Flaherty doesn't remove the trees as Mr. Mark wanted him to, Irene Borba didn't final the project. But it doesn't mean construction time limit was running. Nothing was being constructed. Mr. Mark chose the wrong remedy. When we went to court before, it was just everything was unclear. This whole thing was a jumble, and that's what the court said. And I never got, and when I was here before, I said, what are you fining us for? Tell me. This is Kafkaesque. I use that word. This is Kafkaesque. You're trying to fine us for something I don't know what you're doing. Look at 14.4.2. What is it? What is it we did in 14.4.2? What is it we did in the same statute 30206? What is the construction activity? And there isn't any. Now, let me give you some time limits here to make your thinking clear here. You asked very good questions about the time limits. First of all CTL fines are essentially fines for not complying. They're non-compliance fines. So it is an axiom that in order to have a non-compliance fine, you must have an appropriate compliance order. That compliance order is known colloquially as a sunset letter. You get a sunset letter, and when this project started, the sunset date for the residential scope, not the landscaping scope, which is 90 days later, the residential date was May 28th, 2019. That was the original sunset date. Now, if you go to my handout, number 20, in the resolution you're asked to adopt, it is stated, whereas on May 28, 2019, the CTL deadline elapsed without completion of the project, and the following day, so forth and so on, a 30-day, you got 30 days grace to comply. All right. What was not mentioned, please go to 21. We're having fun here today, I think, because this is an interesting case. Go to 21. This is the resolution in 2022. And you see it highlighted. There was a Tubbs fire in 2018, by which Belvedere extended everything by 60 days. So if you look at the third line down that I have highlighted, whereas on January 8, 2019, the City Council approved an 8-week CTL extension based on construction-related delays from the effect of the Santa Rosa fire, setting a new CTL date of July 28, 2019. No one wants to confront the fact that a compliance letter was not sent out timely to Mr. Flaherty. It's in black and white. It was not sent out. The law was not followed. The law specifically says that the time runs from the time a compliance letter is sent. But the compliance letter was premature in this case. An appropriate compliance letter was not sent. Now, in truth, whereas I think this is fatal to the case, our issue is very substantive. We say substantively, let's assume that, the reasoning is going to be, they're going to say, well, we could have added the Tubbs fire extension after the sunset date. In other words, the sunset date is reached May 28th. We had the discretion to add the Tubbs extension after that, so the sunset date was correct. All right, that's at issue between us here. That's a dispute between and among lawyers. I say the city has already admitted this in the last go-around, that my interpretation is correct. All right, they're changing the interpretation now, but let me get to substance. That's a technicality. I think it's a fatal technicality, but it's a technicality nonetheless. The real issue here is substance. Let me give you the dates now, because they're not really been made clear today. You had that, whether it's before or after May 28th, you had 60 days added to the Tubbs, okay? So that makes July 28 the first date with a 30 days grace. However, there was also a 64-day COVID extension. It's not mentioned here, but it's in the papers. It's in the July 26th, probably in the papers here. But there's there's a 64-day COVID extension. Now, in addition to that, you have 90 days for landscaping. So that leaves the date, and I think Mayor Cooper had it right. That gives the date for compliance with landscaping to February 2, 2020. So when Mayor Cooper asks, gee, do your fines go to November of 2020? Yes, they would. If you're still constructing after February 2, that date for the end of your fines is November 24th, 2020. So if Mr. Flaherty's out there building koi ponds and building things, whether in the landscaping scope or the residential scope, that's when it runs. But if he's not doing construction and he's keeping a tree in the ground, and he's not. So let me give you some other dates here. There was construction within the landscaping scope, okay? But that landscaping scope was heavily, because it's construction, Mr. Van Son's building department inspects it, right? You're not, if it's construction, he should be expecting, his people should be, and they did. They did their job and they inspected. So if you look at Exhibit 9 I have here, this will tell you all the inspections that occurred, all right? Now, if you look at the first page of number 9, it's interesting, you have some, I think the last entry there, I think you might have had one, well, some of these are inspections, you know, that are later, but I think you have a lath and stucco scratch inspection in January 19. You have the gas meter sign off at the end of July 19. If you go through these, just to shortcut it for you, all of the inspections, you won't find an item beyond November of 19. And the ones in November of 19 were not residential construction. The residential construction scope with 30 days grace ended 30 days after July 28. So the residential scope extended till August 28 or August 27, depending on how you count the 30 days. I think it might be August 27. But the conditional use permit was issued August 23, 2019. So there's no issue here, and there never has been an issue as to whether or not there's CTL fines within the residential scope. All right. So the only question is, what about the next days through February 2, 2020? Is there landscaping construction? And the answer is yes, there is, but it was done timely. As long as it's done before February 2, 2020 within the landscaping scope. That would be koi ponds, retaining walls. You will see references in here to shortcut my wonderful disquisition here. You will see that there are some retaining walls and things like that. All construction, all within the landscaping scope after August 27, but before February 2nd, 2020. So you will find that everything was done. If you believe these records of Mr. Van Soen, which are detailed to the nth degree, there's no construction past November of 19. Now, what do we have after November of 19? We do have some limited landscaping work. If you saw, as I showed you before, landscaping work like installing lighting is not considered construction, CTL construction, if it's truly exterior. And I think Mayor Cooper asked the right question, which lighting is what? I think interior lighting and lighting systems are part of residential construction. Landscaping lighting is within the landscaping scope. And it was treated that way in this case. It was construed, but the point is, it was done. It was done. The things that they were talking about, the trees and the lighting that went through planning in the Planning Commission had already been done way back when. They've been done timely, even if it's construction. Even if you considered lighting construction, lighting was done before February 2. Now, it had to have retroactive design review later on, but the actual construction, which is what you care about, that causes the traffic delays, that causes the neighborhood effects, that causes the disruption talked about in these policies. None of that occurred, even if you considered lighting to be construction, which it isn't, it's clearly not. Even if you considered the planting of trees to be construction, well, the planting of trees was 2 days late. Mr. Flaherty owes, if that's construction, he owes you $1,200. Okay, but essentially, there was nothing here that implicated true construction as it's defined, as I showed you in the number 1, after February 2nd. Now, Mr. Flaherty does talk about, and we attach an email from Calvin Craig, the irrigation contractor. Mr. Craig finished the irrigation March 19th, 2020. But that's irrigation. That's clearly within the scope of non-CTL stuff. It's right in there. It says irrigation. And irrigation is not correct. Mr. Flaherty put in the lawn after that. He's unclear, but immediately following, he says it's sometime around March 20 or something, 2019, he puts in the lawn. That is the end of anything he did. Let me make that real clear. I stand by this. Mr. Flaherty will say, and he did it under penalty of perjury, paragraph 19. Mr. Flaherty, did you do anything on penalty of perjury? Did you do anything of construction on this case, landscaping or otherwise, after March of 2020? All right, the record should reflect he said no. And he's already put that in evidence. There is no proof. There is no evidence of any other activity that went on here. Now I will frame our debate. Here's our debate, and here's what's going on here. The issue I would say that's very important, and I'm going to tell you this. It gets really down. We're going to get down to some really serious stuff here in a bit here. Okay. I hate to say it because I don't want to be a heavy guy here. Okay. I want to see you people at some restaurant and say hi to you and laugh about this. All right. The issue here is the fact that Mr. Mark has always wanted CTL penalties for the trees. We have Mr. Middleton confirming that. I've got his emails in here. We've got Ms. Borba, her email from October of 2020, after the hearings, when they told Mr. Mark had him remove the trees. And she tells Mr. Flaherty, essentially, I'm not going to final this thing until you comply with paren small b. Paren small b is removing the trees. Now, he also removed the lights. They unhooked the lights. Mr. Van Sung come in and make sure that the wires were clipped so that Mr. Flaherty couldn't reattach the lights. But that was minor lighting stuff. The only thing that left to be done after these hearings was Mr. Flaherty removing the trees. And guess what he didn't do? He didn't remove the trees. I might be upset with Mr. Flaherty too if I thought it was a big deal. Now, Ms. Borba twice in these hearings in the summer of 2020 the staff recommended that those trees remain. Mr. Flaherty came about this very innocently. He went and he saw, contrary to what's in the record, Ms. Borba specifically agreed on July 25, 2017, that he could plant 2 trees within these revocable license, within the berm. Okay. It's not stated here. People have missed that. The reason it went from 3 approved trees to 2 approved trees, because Ms. Borba said, if you're going to go into the berm, you can only plant 2. So he had approval for 2 olive trees in July of 2017 before he even started. 2.5 years later, he's up in Napa looking for trees. He sees this beautiful ancient tree. He says, my gosh, here I am spending $4 million on my remodel. What wonderful trees. So he ordered 2 trees for $8,000. He thought the only limit on him was keeping that tree to 12 feet. He knew the rules. You got to prune your tree to 12 feet. He knew it was very easy. It's an ancient tree. It's not going to grow any. So he orders 2 of them. He never saw the root ball. If he told you today he saw the root ball or knew that a tree would have a big root ball because it's old, I would say he's lying. Because I don't think that way. You probably don't think that way. Oh, my, that tree must have a big root ball. When the thing gets delivered, it's in a bigger box than was shown on the plans 2.5 years before. Okay, so it turns out the box that was specified was 36 inches. Originally, people thought that the box was 6 feet. It turns out the box is 48 inches. He had a 48-inch box rather than the 36-inch box. Ms. Borba's staff twice said, the trees can remain, just prune the thing. Mr. Mark said, oh, no, you don't. You're removing those trees. Mr. Flaherty tried to have the matter reheard before the city council, before the planning commission. At Ms. Borba's advice, Ms. Borba thought this was a ridiculous thing. She gave him advice as to how to remedy it. Go to the planning commission again and rehear this. He went to rehear it March 16th, 2021. It was on the agenda and it got pulled. In the records, in the administrative record, there's no doubt. It says it was pulled by Mr. Mark on the basis that there was no new information. In fact, Mr. Flaherty was going to present new information about, number 1, how he didn't know the root ball was going to be so big. Number 2, their overhead wires. To remove the tree, you would have to stop traffic, use a crane, and no crane operator that cares about his insurance is going to do anything with overhead wires. You couldn't move it. If he moved the tree to the swimming pool, there's chlorine there, which would poison the trees. There was no place to move it, no way to move it. And Mr. Flaherty thought it was ridiculous anyway, frankly, that Mr. Mark was doing this because he and Mr. Mark did not get along personally. There's no doubt about it. They had a clash. Mr. Flaherty thought he should have handled these things administratively. He didn't. There's a clash. And the real issue before us today is, are you going to fine Mr. Flaherty for contempt of Mr. Mark for not removing the trees timely? Eventually, per the settlement agreement that Mr. Shen put in, those trees can remain. It's fine. We did it. We gave undergrounding easement. The trees can remain, and the city's waived its rights to do the things it should have done, the various actions it could have taken. So, but during the time when the trees were not allowed by the city, and I have maybe 10 emails in here from Mr. Middleton. I put in my own declaration. I talked to him. The only thing, and I'll shortcut all these things because I've got about 10 of them in here. Every one of them says the same thing. This thing is not being finalized because Mr. Flaherty won't remove the trees, and until they remove the trees, it's not finalized. The settlement agreement we reached, and I have it in here, you'll see Mr. Middleton's email to me. Where is Mr. Middleton's email to me? Oh, yes, number 15. It's very clear what's going on here. We have emails back and forth about, sorry, David, you know, you got to move the trees or you're not going to get fined. Okay, so the offer from Mr. Middleton from the city is, Mr. Middleton keeps saying, no, the city's not going to give up on getting fines from you. He wants fines. So we know that Mr. Mark wants fines for Mr. Flaherty. So the offer is, so I've talked to Mr. Middleton for 3 months at this point. He can't get by giving up CTL fines or the right to pursue them, which is what we're doing here today. The right to pursue them. I didn't think they were proper. He thought, the city thought, per Mr. Mark, that they were proper. We're here today to say whether they're proper because he didn't move the olive trees. So the settlement is olive trees would remain in place and your project would be finalized. There is no doubt that nothing was being done on this project. Nothing was being done since Mr. Flaherty's sprinkler system in March of 2020. Now, how does the city explain this? When I brought this up before the judge, everything was always like Jell-O, trying to nail Jell-O on the wall as to why the city was doing what it was doing. So I always said, correctly, I believe, with all these emails I've shown you, that it's the trees were the only thing holding this thing up. Now, it's a very tough position for the city to take here to say, oh, Judge, we want $300,000 in fines from Mr. Flaherty because the trees existed in the ground, not because there were construction trucks out on the street, not because people were bringing in asphalt, not because there were vibrations, noise, parking, traffic, all the things that the building policy talks about, policy 14.4.2, all the things, there's none of that. So what happens? What happens? Let's go to the number 2, the presentation that you've been given here today. There has to be some explanation to the court and to you as people of good faith. How do we tell the city council that it's okay to grant these fines? What was it? Why did the thing stay open for 4.5 years? It didn't stay open for 4.5 years. It stayed open really for a project this size. It finished pretty darn quickly. It was open for 2 years, but that includes some landscaping. Actually, less than 2 years. I'm sorry. It ended March 21, 2022. 2 years earlier was when the thing ended. So what do they say? If you read this, this is really a crux here of what the city's going to say through, I believe, Irene Borba didn't write this, by the way. If you look at it, page 4, do you have that in front of you? On December 2nd, the building department conducted a final inspection and deemed the project final and complete for purposes of the building department's requirements. Let me stop you right there. If you follow the law I quoted, that ends it. Remember the first page I said on number 1 says that when the building department finals it, the remodel is through. Remodel's over, December 2nd, 2020. But the position the city's taken as well. There was all kinds of other stuff that Irene Borba did. Now, Irene Borba didn't write this, but now it talks about, look what she says, that she kept doing work. The work planning did. The work included the removal of unapproved lighting, planting of trees, bushes, and other plants, installation of the irrigation system, placement of ground cover, and the completion of hardscape elements such as walkways, patios, railings, and other exterior decorative elements. What I'm here to tell you is, and this is where it gets serious, this is where the rubber hits the road. This is false and fraudulent. This is false and fraudulent, and I did not make that accusation lightly. I'm an officer of the court. I used to be a federal prosecutor. This is false. It's as false as it can be, and every record you have says it. And furthermore, there are no records of any kind in the file which say that any of this happened. If she's really out there talking to Mr. Flaherty about walkways and patios, it's not. There's nothing there. If she would, there might be an email, a record, a picture. When you do a walkway, don't you take a picture? Doesn't somebody take a picture? Look at the file. You get thousands of pages in this administrative record. People are very complete in this town. They do a good job. They do a good job. You see, everything's drawn. Where is anything in the record that says this happened? It didn't. And what Mr. Flaherty said under oath, and nobody has said this under oath, this happened.
I'm sorry, can you reference where you are pointing to there?
Excuse me?
Do you mind referencing where you're pointing to there? Which document?
Oh, I'm sorry. It is the document I submitted to you today. Number 2. I'm sorry, number 2 in the document, page 4. Now, what I've also done is, for reference, anytime you want to find out if there's any record of what Ms. Borba did, you can go to number 9 and you'll see there's nothing. Ms. Borba puts nothing in the file. There is nothing in the entire administrative record I will represent to you that in any way corroborates one stitch of what's been said here. Not one stitch. And Mr. Flaherty, under oath, has said that this project stopped March 2020, and it was landscaping that he was doing at the time. The construction part of landscaping ended around with the retaining wall in November of 19. All construction landscaping was timely. And I would like to get on the record, Mr. Flaherty, have you had the opportunity to read the yellowed portion I just read to you involving the paragraph starting with on December 2, 2020? Please answer audibly.
Yes.
And under penalty of perjury, is any part of this in any way materially true? Is any of this true?
No.
Is all of it false in every material particular?
Yes.
Okay. This is-
Mr. O'Connor, we're now at 38 minutes, so I'm just going to remind you if there's a way you can wrap it up.
Yeah, okay. You've got my point here. I've attached a bunch of emails that make clear, remember this, there used to be a television program, it's not what you say, it's what you don't say. In all the emails that I've attached with Mr. Middleton, Ms. Borba, and all this, and talking about how you end this thing, does anybody ever say, when I'm trying to settle this thing, does anybody say, oh, by the way, you've still got bushes and trees and decorative elements and hardscape elements? No, it doesn't come up. There's nothing in the record. This is false. This is baloney. And if anyone has to ever testify this, and let me tell you this, and I don't want to be too heavy here, I would do an investigation if I were you. This is false. They're trying to take $400,000 of my client's money, not based on a straight up dispute, which it should have been, do you get money if all you're doing is not removing trees? That should be the issue. But they don't want that issue, so they come up with a lot of BS here, and it's just not true. So I will leave, I will leave that. I hate to say this, but I think you are witnessing in slow motion a civil rights violation by whoever wrote that. And I hope and I pray that you do not adopt it. I would say that as to AB 1561, there's plenty of instances I've referenced before where the town has admitted that the permit was, quote, open. Emily Longfellow told David that she had reviewed it and that AB 1561 applies. And to make sure that time would run out, I settled this matter with Ms. Longfellow September 21, 2021. And everything was supposed to end. And she said, okay, John, let's make this final whenever the easement is final. You'll see the agreement. I said, yeah, that's fine.
I think we've seen it all.
It took 6 months
Right.
before it's final. And if AB
Okay.
1561 applies, guess when the AB 1561 fines run out?
Right.
March 19th, 2022. It's final March 21. This is a game in which Mr. Mark wants to get fines from Mr.
Okay,
Flaherty. And
Mr.
so-
O'Connor, I'm going to ask you
thank
to,
you. Thank you.
okay.
I appreciate your patience, Mayor.
thanks.
Appreciate it. Thank you.
Okay, so we now have the opportunity to ask questions of Mr. O'Connor and Mr. Flaherty. Would anyone like to start in particular? Okay.
Okay. Um, So, I guess Mr. O'Connor's going to answer all the questions. I don't know. But so, Mr. O'Connor, in your documentations, you talk about this sunset letter. And could you clarify what you're talking about as a sunset letter? Because, can you go to the microphone?
Under the law, I think it's 2004-035E2. Before time begins running, when you reach the end of your 18 months or whatever it is your time limit, it might be 12 months for a lesser project. As soon as you've reached the limit of your CTL time, then building's supposed to send out a sunset letter to you. They call it sunset. It's a compliance letter.
Okay.
They call it compliance. Sunset is a term that's not in the law. It is a compliance order, and it calls it a compliance order. And our contention is, of course, one wasn't sent out the right time.
Thank you. Can you tell me why during the construction management meeting, when you were offered, or the applicant or the appellant, excuse me, was offered an additional 6-month extension, that you chose not to accept that and go with the extension in case, and things always happen during construction? Why
Well-
would you not accept that?
Well, I don't want to be lawyer-like, but it's academic if we've complied with all the timelines. It's what?
Why were you even asking that? We didn't do anything wrong. There's no time violation.
Yeah. I think Mr. Flaherty's remark that what I just said, we don't think there was any violation. We did things, if you look at the number 9.
No, I'm talking about in the construction management meeting back in the beginning,
Okay, you
back
answer
in
why you didn't do it.
27, 18, whatever.
So I was never offered a 6-month extension. I'm not sure what Brian's talking about. I can tell you, nobody came to me. Irene Borba was my partner along with Brian. Brian on inspection, Irene on planning. Irene Borba did nothing but try to help Julie and I complete this project in a timely manner. And so I can tell you that had David Hughes or I been aware of a 6-month extension that cost nothing or minimal, we would have unequivocally asked for it for one reason. It's hard to get contractors to even want to do jobs on this island. We have a horrendous reputation in Belvedere. I hope you guys know that for any construction work. I mean, people just don't want to work here. I have a project on my street. The people are doing a great job. Yeah, is it inconvenience at times? Do I have to stop? Do I have to wait for things? Sure. But having gone through the nightmare of building on Belvedere and wire projects being pulled left and right on Belvedere for large projects, nobody wants to do this. I would never do this again. And so the idea that John, and I think he's presented this incredibly well, unfortunately, Brian's notice is completely wrong on just
Okay,
procedural.
I'm sorry, you're going beyond my question.
Yeah. So
Thank you.
next question.
Yes, next question.
You didn't get the 6 month.
No, I never got that.
Okay.
Did you realize that when you started making design changes, that it would potentially not only be more expensive, but prolong the construction process?
Are you talking about the retroactive design approvals?
I'm talking about all the design review exceptions and exemptions and everything else.
Well, there
Everything.
were none that delayed it. There were
Okay.
none that delayed it at all. The only thing he did that he looked for a retroactive design exemption on the lighting. But the lighting was done timely. The question is whether it would be approved. It wasn't, so he unhooked it. So there's no issue there. There's no issue.
So can you explain why your landscape architect put on the landscape plans in 2021 that they were 72 box olive trees? Was the architect put on the plans that the olive trees that were going to be planted were going to be 72 box? Do you know?
I don't think that, I don't know what you're talking about. I do know that the tree service said that the trees would be delivered in a 72-inch trailer.
Okay.
But I don't, but it's clarified. Ms. Longfellow in our settlement agreement acknowledges it was a 48-inch box. And also you'll look at the ARC, we put in evidence, the ARC article of March 31, 2021, in which the city confirmed that it was a 48-inch box. So it was a 48-inch box. It should have been a 36-inch box. There's no doubt about it. We're not contending that, but it's very clear. Julie wrote to the Planning Commission in early 18 saying, oh, by the way, it was a 48-inch box. Everybody checked it out. It's in the record. It's a 48-inch box, but it was too big. It was too big. David didn't know it'd be too big. It had a big root ball. And now here he is.
Thank you. My next question is, did you need a crane originally to put the plant the olive trees?
Did I need what?
Did you need a crane? A crane?
No, we didn't use a crane at all because the power wires came right over the property in the street. It was before we undergrounded.
I think David.
If I could just ask a follow-up on that.
Sure.
So you're saying you needed a crane to take them out, but you didn't need a crane to put them in.
That's right. And
So
David
how do you
talked-
get them in?
And David talked about it on the record. It was a real battle. You have to take these things, they're very heavy, and roll them in. David will tell you about it.
So I've never planted an olive tree in my life, so I sure don't know or claim to be an expert on olive trees. But the way the trees were brought to us in the 48-inch boxes is we actually planted the entire box. So we literally had, I don't know how many men. It took our people from Hughes, the delivery people, everybody to lift these things and put them into place. And so what became a real issue is when the city issued the order to remove them, I wouldn't even know how I began to do that. And that's where the crane came in.
And let me follow up on that. I have talked to the olive tree people, Mr. Tyler Heathcote, who delivered it, and he said you would need at least 100-ton crane to remove it. If you wanted to replant on another part of the grounds, you would need a 375-ton crane, and you shouldn't do it because of the pool and the chlorine. That's the only site you had. And so you would have had to have a massive crane, and then you have the overhead wires. So it was practically speaking impossible to remove the trees.
So in your documentation, you state that, or you claim, I'll say, you're unaware of the CTL fines running due to the non-compliance of the Planning Commission conditions set by their design review resolution. Yet in the October 26th letter, 2025 from Mr. O'Connor, you were aware that it was going to affect your CTL fine in the statement of number 19 and number 20. And that also from March to September 2021, you tried to negotiate your item number C, not to have the resolution enforced for the non-compliance of the Planning Commission design review resolution.
Right.
And then again in October 13th of 2020, in an email you gave us in your declaration, I don't have the number,
Yeah,
but
right.
you state you were aware that the non-compliance was going to affect your CTL.
Not true. That we knew that the city would take the position that the non-compliance would affect the CTL. We knew we were going to be in a fight. We did not ever agree that these CTL fines would be fine. Ms. Borba told us on October 13 that Mr. Flaherty had to comply with provision B of the Planning Commission in order to get finaled.
So my question is not whether you agree or not, but rather you were aware that non-compliance with the design review from the Planning Commission resolution was going to be affecting your CTL. You were aware that that was an issue.
Was I aware that Mr. Mark was going to try to get fines from us? You bet your boots. He's always used the wrong remedy. I've said that. He uses the wrong remedy, and Ms. Longfellow basically says that at 1597, and she says it in the settlement agreement, that there's another way to do this. Yes, we always knew, and we're here today because I know Mr. Mark wants his fines. And I'll tell you that until the day I die, that he wants the fines here. And even though I do not agree and have never agreed that the fines were appropriate.
Okay, and then Mr. O'Connor, one thing I have here is that in your letter dated 11/26/2025 on page 2, paragraph 7, you state that the city council made mistakes in the package of July 11th, 2022. Or you state that it's, here I'm correcting myself. You state that they made mistakes in the July 11th, 2022 package for the original review. And I think you meant to say that it was July 11th, 2022.
Yes, if you look at number 18 in the that I gave you today, I state correctly the date July 11th, 2022. In that, what I wanted to tell you was when the council heard this before, they had an incorrect calculation by the city as to the effect of the 18-month AB 1561 extension. I have it in here. The incorrect calculation is off by 13 months. As I explained before.
Okay, that's not my question.
Okay,
you're giving me an argument, and that I'm asking
No,
questions.
I thought that's what you're asking me. Sorry.
No. I'm saying that you have July 11th, 2025, and I think you meant to say 2022.
Oh, okay. Yes.
Okay, that's
Okay.
all I'm trying
I
to
stand
clarify,
corrected on
not
that. Sorry.
clarifying anything else.
It's hard to get a short answer from a lawyer. Have you figured that out
I
yet?
know, but I'll keep you to it as much as I can.
Sorry about that.
Also on page, just clarifying some, technical little things here. So on page 6, number 23 and 24, you state that the agreement date was 10/11/2021 for the easement. We're talking about the easement.
Right.
But the actual signed agreement or the actual easement agreement states that on this date, October 26, 2021. So we are talking about the same document,
Right,
the one that's dated for October 26,
right,
2021.
right. I
Okay.
think you'll see that Miss Longfellow and I exchanged drafts, and I actually thought it was October 11th that we actually came to the written agreement, but if we signed it later, that's fine.
Okay.
I submitted
Thank you.
something here,
Thank
yeah.
you. So also on the August 20, 2020 Design Review Planning Commission hearing.
Right.
We were talking about lighting, unapproved lighting and the 2 olive trees. There were additional things that I believe were not retroactive, but were added to that design review. And it included 2 railings, one around the tower and one above the entryway doors, the best way I can describe it. It included a trellis and it included some guardrails on the driveway. So in August of 2020, it looks like railings, trellis, and guardrails we were adding to construction.
Well, as you have to go through the record, and I know that's difficult now to do it, but a couple things. Number one, you'll see a record that the metal trellis later on was withdrawn, whatever the request was. You will see that this is very odd. On March 21, 2022, when this permit was finalized, there was a separate permit that Ms. Borba issued that both she and Mr. Von Son opened and closed on the same day, that had to do with a metal railing and a metal gate. I think it was a metal trellis and a metal gate. So that ended up being a separate permit. But what I will tell you is nothing happened after of any, no, you won't find anything in the actual record where there was actually something done after those planning commission things. Now, this may be one of the things you're referring to. Mr. Flaherty asked for a retroactive exemption on a railing he'd already built that was wood. He built it back in around February.
No, I'm not talking about a wood railing.
No, it was approved as a metal railing. And he asked, because he couldn't get metal from Europe, he asked for a retroactive design review to keep the wood in there that he put in months before. And that's in the record. In other words, there was wood existing from early 2020. On August 31, he asked Ms. Borba, look, I can't get the metal's still not coming in. Can you allow me to keep the wood? Can I keep the wood?
Okay, I'm very familiar with the project. Can you tell me if that, Mr. Flaherty, can you tell me if this was the railing that went around the tower? You had a railing around the tower with some planter boxes. Was that the metal railing that became wood?
No. So the metal railing, all of the house was done. When we say done, Brian couldn't have finalized the house in August or whatever date it was for us to move in without railings. Where we had issues, and they were very minor, was we required one driveway metal railing that we just didn't know about. And all the plans were submitted, they were approved, but we didn't know until Irene came up with Peter and said, hey, you need a railing on this wall because it's too much of a drop. I think part of it was, the property is extremely steep. So when we submitted our original plans to the city, somehow it just got missed. And clearly that was a surprise to me. The other surprise was on the lawn. So I put up wood railings within 2 weeks. The house should have been finalized immediately then, both building and planning. There was no work at all involved in anything. I don't know what you're talking about with towers. The entire house was complete. There was nothing left.
Okay. Okay, I'm going to pause while I gather my questions again. So if anybody else wants to lead off.
Perfect. Anybody else have questions for Mr. Flaherty?
Sure. One question, if you go back to tab 1 in the handout that you gave us today, the highlighted section, are you saying that you did not, you weren't aware of what's in the code 2004035? Because in the code, unless it's changed, which again, it could have since the time this was done, it specifically says that a project isn't finalized until these 4 steps. I mean, it's pretty specific. And so are you asserting that this is somehow different or?
I'm trying to think if you're talking about 1416 in number 1, page 1416. Are you talking about the signatures?
Well, the way I read this, what you highlighted in 14.5 is as it relates to 14.5, conditional temporary certificates of occupancy. I think you were trying to make the point that therefore would suggest the entire project in total is complete. But if you actually go and look at our code 20.04.035, it's pretty specific in terms of the final inspection and completion of projects must have the following if appropriate, which includes Tiburon Fire and Protection, Marin County Sanitary, the City of Belvedere Building Department, and the City of Belvedere Planning Department.
Well, what I would say is August 23rd, we got our, at the time, unqualified certificate of occupancy. Later on, it was reissued as temporary conditional certificate of occupancy. But the point is, no one in good faith here but who's familiar with this, and I know you're just getting into
But again,
it.
going back to the code, is that, are you saying that you weren't familiar with this code
No,
or?
no, I'm saying there is no issue about residential construction. There's just not an issue here.
No. Again,
It's-
what the code says is it's required that you get all 4 things. Are you saying?
For the residents you're talking about?
Correct. That's what it says.
Well, I'll just tell you, this is a new one. There's never been an issue on the residents not having
Okay.
been.
I just wanted
done.
to
I mean, I've
clarify
been through
whether,
this for the last
because there
3
are different
years.
pieces of code referring to different things. I just want to make that.
It
So
may
my
well be
next
that-
question, no, got it.
No, those questions didn't come up is what I'm saying. Nobody's ever before, you may be the first person that figured this out, but no one has ever said that is an issue in this case. You may be.
Well, it's not an issue.
correct.
It's what the code says is required in order for a project to be considered complete is
I
these 4
understand
things.
that. I
Okay.
understand that.
All right,
but-
great.
but-
I'm glad you do. And then in your tab 2, I believe it's, sorry, no, tab 1, if you continue on, I think it's page 1416. It's, if you flip pages, it's really the 4th page. The final bullet, you had cited this again, and I just wanted to call our attention back to it, where you were saying these are the things that are not subject to CTL final approval. All softscape improvements, including approved plan materials and trees. But I think we've all acknowledged that based on the retroactive design review, which was in August of 2020, it was made clear that the trees were not approved.
That's why when I brought this up, I acknowledged that was so. And I said, if they're not approved, if you read this to say, it doesn't say unapproved trees are construction, but if you read it with a negative inference to say unapproved trees are construction subject to CTL, that's why I told you before, we pay $1,200 because the record is unrefuted that we put those trees in February 4th, 2020. So that's why I said earlier, to be as forthright as I could with you, that we owe $1,200 if you interpret this to mean that unapproved trees is construction. I would say even unimproved trees still is landscaping.
But again,
But-
the words on the page say that it doesn't include approved plant material and trees. And
That's
as I
what
just said,
said.
these trees were unapproved. I'm
That's
just,
what I said. That's $1,200. I have a check right now, pay you $1,200.
okay. I just wanted to clarify that for
Thank you.
myself. That's all I have right now.
Okay. Councilmember Wilkinson. Oh, did you want to go back, Pat?
No.
Okay.
Thank you very much.
Can I follow up with a few extra questions? I'm
You're
sorry.
not done yet.
You're not done.
Get back, go back,
Back on the griddle.
back.
So I understand your assertion is that everything was complete on March 20th, 2020.
Right.
And yet the building department didn't final until December 2nd of 2020.
Yes. Yeah.
Is it okay for me to ask both council,
Yeah.
our city council as well,
Yeah.
that question?
Let me address this. The whole idea of the CTL law is that there are times when the file is not ended, the building hadn't signed off, but CTL time doesn't run. So what I would say is not only it doesn't run if there's construction, landscaping, and it certainly doesn't run if nothing is being constructed. So from March 19th or March 20th to the time building finalized on December 2nd, nothing was being done. Now you had these design review hearings about the lighting. There's a lot of folderol there, lighting, trees, lighting, but there was no construction. And there was not even, past March 19th, there wasn't even pure landscaping, which is not considered CTL. You didn't even have landscaping after March 19th. Everything had ended. And the only thing that happened after that is Mr. Flaherty disconnected the lights pending the hearing. And after he lost the hearing, Mr. Van Sonen, he made sure the wires were snipped so he couldn't reconnect them. But no additional lighting work was done, not even though it's not considered CTL stuff. No pure landscaping was even done after March 19. So, and then there was pure landscaping done between February 2nd and March 20, although Mr. Burke brings up a point. If the trees are considered unapproved and therefore construction, then they were constructed 2 days late. We've given you the right date on that, and it's February 4. So that looks to me like pure landscape. I would argue that that's pure landscaping, but nonetheless, you've got pure landscaping up to March 20th or so, and then nothing for the rest of the year, which is just basically what the planning and commission should be doing, what everybody should be doing, is you're dealing with retroactive design work. That happens in every project. A big project, there's going to be retroactive. Oh, we put in this, we didn't have approval for it, we decided to move the plant. Do I get retroactive design? Happens every project. That's what was going on that summer. A lot of it is handled administratively. This one it wasn't, and that's why Mr. Flaherty and Mr. Mark got into it. Mr. Flaherty thought this should have been done administratively. They got into it. They don't like each other.
So I think there's a misconception. It's not just you have a problem that both your city attorney and your head of planning came and told me that there's no CTL at any level. I mean, all this is on record. You have it in writing. It's much worse. I mean, the idea that I helped underground with Suzanne Dumoulin and Greg Wood and solely build the lane because the Winslows only give you the money because they called me and said, David, can we build off your property? And I have to deal with the license with the city, which I did. And Irene Borba, and for the most part, Brian really helped me. But Robert will tell you, he authorized the easement across my property. There was no agreement to easements. We were trying to help each other. Clearly, Robert made a mistake. Brian unequivocally made a mistake on Sunset. It's just pure and simple. And so for you, Sally, to ask me, is there any construction? I don't assume there's any fines. I have no idea why you didn't close the file. That's the biggest question I have.
That's I've handled it.
Do you think I can ask staff to just, I'd like to ask staff to clarify what happened between March 2020 and December.
There were hearings.
Yeah.
I'd like staff to
I'm
clarify
sorry. I
that
didn't
for
know
me.
you're
Thank
asking-
you.
You're asking them. All right.
We don't have much record in regards. We do have on the city's inspection card, as well as an email from May 2020 that talks about final inspection being conducted, or pre-final, excuse me, and corrections being needed. So it's safe to assume that any of those corrections were made at some point in between May 2020 and December 2020, and would therefore obviously have work going on at that point.
We can pass out copies of the email to you guys, and I'd just like to add that some of the construction of some of the pre-final boxes that needed to be checked included retaining walls. And you'll see in the email, it's a whole slew of retaining walls within walking surfaces at the southwest side walking surface, the garage, southeast side, below the hot tub, rear of the house, below the driveway, above hot tub, and the east side of the pool, fire pit area, et cetera. So I would imagine that if these retaining walls are being constructed, there's some type of construction happening at the site. And this email is dated May 2nd, 2020. And we have on our inspection card that Gennaro, it was part of his pre-final in May.
And if I may just add one point, Sally, or I'm sorry, Vice Mayor Wilkinson, that May date that Rebecca just referenced is actually included in the appellant's materials. If you look at tab 10, which is one set of the inspection cards. If you look on the last page, it does indicate that there was an inspection that occurred on May 26, 2020. It's the only entry on that page.
Okay, so that would suggest that in fact there was activity after March 20th, 2020.
Yeah, if we could add a little bit as well, if you don't mind.
So there was an assertion made in that highlighted paragraph by Mr. O'Connor that is implicitly false. Again, after the building department had finalized the permit on December 2nd, 2020, we went on December 1st and December 2nd to verify the wiring for David, which he probably recalls meeting me there. Him and I were at his panel with his electrician and everything. As of the 2nd, there were other aspects of the job, meaning other, I don't want to call them contractors, but other workers there that were other than the electrician. And then signing it off and then speaking to the director of planning and building at that time, it was our understanding that that scope of work or elements of that scope of work in that paragraph still needed to be completed at that time.
Thank you.
I don't know what that means.
Sorry, turn myself on. I have a question for staff follow-up. So we talk about construction, what constitutes a CTL completion or not completion, something that shouldn't be considered on the fine process. And isn't it also not just that it's quote unquote construction, but it's also the noise and the actual people and or workers still on site? I mean, there's a whole list in under 14 where there's not supposed to be any porta potties there. There's not supposed to be any equipment. All temporary fencing is supposed to be done. I mean, that is kind of like the end of construction. So when we talk about construction, we're just not talking about nail and hammer and concrete and that kind of thing, but we're also talking about work that involves having workers that impact the parking in the neighborhood, the noise. And then additionally, were there any encroachment permits that were issued beyond during these times where supposedly all the work was supposed to be done? Where
in the context of the CTL, construction activity would be defined as any work being done to complete the approved project. Again, it'd be painting, it'd be things that are outside of the normal jurisdictional authority of the building department if taken solely by themselves. In regards to the encroachment permits, let's click on the date. Okay. Encroachment. So that's all, yeah. I mean, that's all early 2020. It doesn't, yeah. So in regards to the encroachment permits, no, we do not show a record of anything, really anything being done after, what date is that? That's a residential one. Basically June of 2020,
June of 2020.
correct?
But that's just for encroachment. It doesn't mean that the workers weren't there. or
Correct.
work
That
was
is,
not
that
going
is
on.
merely or purely the encroachment permit application and issuance by the Public Works Department. That doesn't necessarily dictate that there was no other work going on at that time.
Brian, on the website, it mentions a permit with the date February 10th, 2021. And it says construct metal trellis at side yard as approved under BP 2017-173 and install guardrail at driveway. Are those things construction?
So the trellis was a part of the original approval. It was then omitted through the planning process. And then when we went back out to inspect at some later point or a final, it was constructed. We issued the permit in order to legitimize the construction of the trellis for Mr.
Oh, so
Flaherty.
this was a retroactive.
For the most part, the trellis, the original approval for the trellis was
Okay.
in the 173
Got it.
package. It was then at a later date removed, therefore could not be constructed. When we went out, it was constructed, and Ms. Borba and I assisted Mr. Flaherty in obtaining legal approvals for the construction of that trellis.
So-
In regards to
okay.
the guardrail, I believe there was a change in landscape at that point, which created the fall hazard and the retroactive installation of the guardrail. Because on the original plans, there may not have been that fall hazard, but because of changes throughout the process which are documented, this now became a greater
Safety.
height and a
Yeah.
larger safety issue, at which point we had to say, hey, you need a guardrail here.
So, and that would be considered
Yeah, someone would have
work,
to install and or construct
Okay.
that.
And that was in February of 21, are you saying?
I don't have the date off the top of my head. I apologize.
But that's when it was approved, so.
No, it would have,
The trellis was already approved.
Was it a building permit, James?
I
That's
have
what
no
we did.
clue what kind of.
We did it all for the
Building
plan.
permit was issued, but the trellis had already been, had previously been constructed. I'm not sure if that guardrail has been constructed.
I think again, we went out and noticed that due to a change in the landscape plan, which would
Okay.
not have gone through the building department.
Okay,
But because we did notice it out on site, it is our responsibility to make sure it is safe.
great, thank you. Okay.
I think I just have one or two more questions. You've asserted throughout that Mr. Mark was somehow very heavily involved in this whole situation. Mr. Mark was a planning commissioner and certainly had no authority to be negotiating CTL fines or easements or anything else, and was not involved in that process at all. And so I'm just trying to understand this extended period between when the building final and the planning final happened. A lot of that seemed to be around some of this was around this negotiation of the easement, which had nothing to do with Mr. Mark. I'd like you just to elaborate on where you think this animus played into the process, which is a government process, not a personal process.
Well, we have emails here in which Mr. Middleton says, and talks originally to Mr. Emery around November of 2020. This has been going on. And Mr. Emery has said in his declaration, Mr. Middleton told me that it is the CTL fines for the trees and no other reason that this thing is not being finalized. Those were my conversations with Mr. Middleton. There is no doubt. Now, do I know where that was coming from? Do I know who it was that was advising them, no way will this go forward without this? Well, I don't think it was up to the council level at that point. I think this is still a planning matter because Ms. Borba said on October 13, you've still got a planning approval here. So I don't know why it wouldn't be within planning commission authority as to whether or not to remove condition B of the Planning Commission approval of August 18, 2020. It was clearly within Mr. Marks. I don't know who's directing Mr. Middleton. He's not telling me, but clearly somebody is. And then the answer should be, is it somebody from the council? I don't think so, but maybe it was. But I suspect logic would tell you that it's Mr. Mark. That's all. And I think it's no doubt about it. And Mr. Mark makes very intemperate remarks about Mr. Flaherty in the March 21 issue of the ARC. There is no doubt about it. It's around that time that he pulls from the agenda that which Ms. Borba had Mr. Flaherty do. Let's go to because he had no opportunity to respond as to the problems with removing a tree. So Ms. Borba says, well, David, put this on the agenda and we'll go to the Planning Commission and we'll have you give us your information here so that the Planning Commission can reconsider whether to remove. Mr. Mark pulled that from the agenda. It's in the records. I'm not making that up. And he issued it for the reason no new information. He was the one who pulled that, even though Ms. Borba thought it was appropriate. So no, please. And if you put that together, everything would seem to suggest maybe there's somebody else that feels just like Mr. Mark that's doing this, but he's doing everything at that point. He's being quoted to the ARC. He's pulling the matter from the March 21 agenda. So Mr. Middleton is telling me there's no way I'm going to get away from seeking CTL fines. We know Mr. Mark wanted CTL fines. We know Ms. Longfellow had advised him otherwise as to the right remedies. So maybe it's another planning commission. Maybe it's somebody I never heard of. But logic and circumstantial evidence would suggest who else could it be? So I think that the real point here is there's a $300,000 fine here for what we're really talking about is trifles here. We're talking about trifles. You have the authority to knock this fine down. You have the authority to do the right thing. $300,000 for this, by the way, will not meet constitutional muster.
Thank you. I think you've answered my question. Thank you.
Okay, but I would add that this has got a constitutional problem with $300,000 for this.
Okay, I have a couple of questions. I actually listened to the pre-construction meeting that was held between Mr. Von Son, Mrs. Flaherty, and I don't know your contractor's name. I apologize. And in that meeting, the 90-day landscape extension came up as well as the extra 6-month extension option. So unfortunately, your statement that your contractor didn't know anything about it doesn't seem accurate because he was sitting there and I listened to the tape recording of the meeting where it was mentioned. So I think he did know about it. Perhaps they didn't share that information with you. I don't know, but certainly the contractor and Mrs. Flaherty were aware of it. Okay.
That's the answer. Ms. Flaherty was there. He wasn't. David
Okay,
wasn't.
I'm
So,
just saying she
yeah,
was,
yeah.
I'm assuming she's an owner.
No, that's well taken.
And, okay.
Well taken. Thank you. Thank you very
Sure.
much.
Because I know that he was swearing on everything. So I wanted to make sure that this one was clarified.
Yeah.
The other question I have is, I wonder if you dispute that your signature was on the certificate of temporary occupancy, which we all have copies of with your signature on it, in which case I'm assuming you read it and know that it said that the temporary certificate does not final the project at all. It has to be finalized through building and planning.
I understood everything, but
Okay.
because the project was on time, we didn't even think about it.
Okay, thank you. And then you made the statement that there were retaining walls, but they wouldn't fall under the CTL final approval. Does that mean that your retaining walls were only 1.5 feet high?
No, you misunderstood me. The retaining walls there were some that were higher than 1.5 feet, but they were done on time. You'll find it in the
Okay.
Exhibit 9. You'll see them inspecting, Mr. Van Soens inspecting the retaining walls, finding they're fine. There was, the koi ponds were in there. There's some construction within landscaping that we do not deny is construction. It just happens to be timely before February 2nd, 2020.
Oh, okay. I misunderstood that, sorry. I guess the other question I have is I also listened to the August 18th, 2020 retroactive design review meeting with the Planning Commission. And it was made clear there a lot of conditions after a lot of questions, a lot of concern. I heard the planning commissioners really trying to make this work. Everybody was overwhelmed by the amount of construction that had been done that was unauthorized. And yet they were all trying to figure out a way to move this forward. After that meeting, it's pretty clear that the applicant or Mr. Flaherty had the opportunity to appeal their decision. And yet he chose not to appeal it. And during the meeting, he even made statements like, I want to make this work. I want to comply. This is, his goal, and he did not appeal. I'm just wondering if the conditions were so horrible for him, why wouldn't he appeal it?
Well, for one thing, he did not have in the record, and this is why Ms. Borba advised him on this. So I'm not just talking through my hat. Ms. Borba talked to him about this. He never had a chance. You read that. I've read the same transcript. You won't see anything in the transcript about the difficulties. This order to remove the trees came out of the blue. It wasn't as though he was told in July.
I
By
know,
the way,
but he
Mr.
could appeal. He had the authority and the right to appeal that decision by the Planning Commission.
You're technically correct.
No, I'm not technically correct.
No.
I'm correct.
No, you are correct. But my point is, you're appealing it without having fleshed out the record. Anybody knows that if you appeal, you should have facts in the record. That's what Ms. Borba was advising him to do, to go to the Planning Commission and talk to them about all the things that you didn't say before, because otherwise you're going to appeal. And when you appeal, you're limited to the record you have. Well, David was never asked, are there problems with moving this thing? He was never asked. They never got into the overhead lines, the ability to replant. So my point is, Ms. Borba advised him, and Ms. Longfellow, both of them advised him how to have this heard so that people could operate on full information, which is what you want, which everybody wants. And when he did it, the record is clear. Mr. Mark pulled it on the grounds of no new information.
You're talking about a different meeting though. So what I'm saying is everybody has the right to appeal, just like today, right? And it comes from the Planning Commission to the City Council.
Absolutely.
I'm not talking about going back to the Planning Commission again. I'm saying every individual that comes to the Planning Commission, if a decision is made that they don't like, and believe me, this happens all the time, it is appealed and it goes directly to the City Council, where the administrative record could be added to, just like today, the administrative record's added to. The same thing happens. There's no limitation.
You're right.
You're given time, you can prepare, and you come before the City Council. And that was apparently something that Mr. Flaherty chose not to take advantage of. And then therefore allowing these rulings or conditions by the Planning Commission to remain because there was no appeal. Coming back 6 months later was not in our code. You're supposed to appeal it right after. That's all I don't understand why that didn't happen.
Please, David, technically.
Because everybody knows about it.
Technically, you're right that he could have appealed. I will say he did not have a record of any kind.
He didn't need one at that time.
Well, also, the planning commissioners had not heard any information. It's not clear that the Planning Commission would have stayed the same. They did not hear any of the information that Ms. Borba and Ms. Longfellow, who are not rookies on this, told them that they should do. Go tell the planning commission all the problems. Maybe they'll understand. That seemed to me to be a very amiable thing to do, rather than running up to a bunch of people who haven't been involved in this. Go back to the people who made the decision. And I don't know for the life of me why Mr. Mark would pull that other than for personal animus. There's no doubt about it. Why would he pull
Okay,
that from?
well, I'm
a
going to
commission?
leave Mr. Mark out of this because I think there was also policy involved. It was not a personal opinion. There was policy involved. But in any case, to go back to that meeting and the ability to appeal, I was just asking why the appeal didn't happen in the correct time frame, and there's no answer apparently.
Yeah, he's
So-
not, he didn't do a good job of being a lawyer. That's all.
Okay.
That's all I'll
So
tell you.
then my question
Can I
on,
answer your question though? Because there's a really simple answer. There are no issues. Have you looked at what we're talking about, going back to the planning commission?
that's not what I was asking. Yeah, I get it. I get it. I get it. Right, right. I get it. That's okay. Because of getting the notification by Ms. Borba and the city attorney at the time about AB 1561, do you, and I think you've said in your own statements that you became aware of that with a phone call either in late October or early November, sometime in there. And did that affect the remodel at all? Was there an issue with that would affect the remodel itself?
No, the only thing that affected was whether or not the city could get fines.
Right.
And that was basically it, Mr.
But it didn't hold up or delay or postpone
There was-
anything?
There was
Okay.
nothing being done at the time. In other words, our position is there wasn't anything to do other than hope that we didn't have to remove the trees.
Okay.
That's all.
In your other information, not this one, because I don't know where it would be in here, but all the other hundreds of pages you sent, you mentioned a lot about administrative appeals. What is an administrative appeal? I don't know what that is. You said there were delays because of administrative appeals that caused delays of the project.
Well.
I don't know what an administrative
Well,
appeal.
our position is now, it doesn't make any difference. There were some administrative appeals as to different little things, but it doesn't make any difference because everything was done timely. So
Okay.
we're talking about, it doesn't make any difference. Everything was done within time. Now, maybe there was some trellis or something that came and went, but it was done. It was done when we said it was done.
Okay.
I don't think he's talking about appeals. I think he's talking about exceptions and exemptions on design review. But anyway, it doesn't matter.
Okay. Were you ever given any stop work orders?
No,
Okay. All right, that's it for me.
All right.
Okay, thank you.
thank you.
Sorry it took so long.
Oh, no, I'm sorry I took so long.
Everybody's taking long. So, okay. At this point, I'd like to open up for anyone in the public. Am I wrong? To make a statement or comment or have a question answered, and you have up to 3 minutes. If anyone here would like to, please come up to the podium and introduce yourself.
Excuse me. My name is Greg Wood. I live at 205 Golden Gate Avenue, Belvedere. Full disclosure, I've known David Flaherty for about 25 years professionally and socially. So being a resident, especially on Golden Gate Avenue, we live with construction. The house above me has been remodeled twice, to my left once, down below one more time. So we put up with it, and we just hope that the construction that takes place enhances, the property that they're doing the work on, which will in turn enhance, our property values. So before David got involved with 339, it was known as a pink house. We all remember that, and there were wires going all the way across. It was interesting, but it was a mess. When David purchased it, I told him he was crazy. Why would you do that? But he went ahead with the project. And what's interesting to note is that He could have just put up a glass box on the property like everybody else is doing. But he chose to follow through with the original 1912 architecture. And he did a beautiful job. He was also involved with getting the wires down because they were crisscrossing all across the area, and he promoted the lane. So from a perspective of a homeowner on the island, David did a great job of enhancing the island, the property. Okay, so you got to give him that. And so, I mean, again, I mean, it's considered one of the nicest properties on the island. It's beautiful. And he kept the original footprint. It's beautiful. You can't beat it. So I just want to say that. But also, listening to everything going on here, I'm really disappointed that Commissioner Mark is not here. A lot of it is centered around him, and he's not here to comment. And quite frankly, I mean, a lot of this is new to me. And I would like that person to be here. This seems to be the crux of the matter here, because there is some personal animosity. I would like to hear what he has to say about that. So from that perspective, I'm very disappointed in this meeting. Thank you.
Great, thank you, Mr. Wood. Is there anyone else?
Hi. Hi, my name is Lauren Drian. I'm a resident at 301 San Rafael
Can you
Avenue.
speak in the microphone?
Sorry. Hi, I live at 301 San Rafael Avenue in Belvedere. I'm also an attorney. So I am here to respectfully oppose the CTL fine of $300,000 that's been assessed against this family. My opposition is grounded in two principal concerns. First, the magnitude of the fine is excessive. It's constitutionally excessive. And given the actual construction timeline. And second, circumstances of this matter raise significant policy concerns that will adversely impact the willingness of homeowners to maintain and improve Belvedere's historic housing stock. First, the record indicates that all of the construction here was completed in January 2020. For reasons that remain unclear, the file was kept open long after the work itself had ceased. During that period, there was no construction activity, no disruption, no noise, and no impact whatsoever on neighboring properties. To impose a six-figure penalty under these circumstances, where the core purpose of the CTL is to mitigate active construction impacts, makes the fine not only disproportionate, but unconstitutionally excessive under established due process and proportionality principles. Second, as a Belvedere resident who has myself undertaken a much smaller scale renovation and experienced substantial delays due to labor shortages, contractor turnover, and the unique structural and logistical challenges of building on Belvedere Island, I can personally attest to how difficult it is to complete even a modest project here. The CTL ordinance serves an important purpose, but it was never intended to punish homeowners for administrative delays or circumstances outside of their control, nor to penalize families long after construction has ended. Here, this family took on a property that was significantly deteriorated and historically significant, and made substantial improvements that have benefited both the neighborhood and the broader community. Their investment transformed an aging structure into a well-maintained home consistent with the architectural character of Belvedere. Penalizing homeowners, especially in cases where they receive no meaningful notice and no opportunity to remedy an alleged violation, will have a chilling effect on Belvedere. It will discourage residents from preserving and updating historic properties, ultimately working against the very aesthetics and values the city seeks to protect. For these reasons, I respectfully urge the council to remove the CTL fines associated with this property. Such an outcome would be consistent with fairness, constitutional principles, and the long-term interests of Belvedere and its residents. Thank you.
Thank you. Is there anyone else here who would like to comment? Is there anyone else Zoom?
Mayor Cooper, we have no hands raised.
Okay. I would also like to note that we received 7 letters regarding this project. I wanted to note that we received 7 letters regarding this project. Mr. Johnson, Ms. Clough, Ms. Donnell, and Mr. Fagioli were in support of the city ordinances. Ms. Lund, Mr. Barber, and Mr. Wood support waiving the ordinance. All the letters are posted on the city website and can be read there. Okay, in that case, actually, does the council have more questions for the staff?
I have one question. Oh, here it is. Okay. Can you clarify when the planning department does their final, that in order to be final, that all projects need to meet the design review given to that particular project?
That is correct.
And if they don't meet the design review, then you cannot final it?
That is also correct.
Thank you.
I have one question, which I don't know if it's possible for our attorney to answer it or not. But, and I'm not sure I remember what page it's on in this binder. But where Mr. O'Connor said we were breaking the law or something, there was some horrible thing. I don't remember what you said.
Yeah.
It was
so-
something horrible.
Yeah.
In my binder,
Yeah.
yeah, I don't think I've accused counsel, who are very ethical people.
Oh, here it is.
Mr. Shen and his firm are very ethical. I'm
Page
not-
4 under.
Well,
Pat
yeah,
two.
if I may, thank you for the
Yeah.
opportunity, Mayor. With all due respect, while I appreciate Mr. O'Connor's kind words about my firm, I also feel the same level of integrity applies to all city staff that are sitting at this table with me. No one here is acting out of any ulterior motive and is unconcerned with anything other than the facts. And I just want to make sure that everyone understands, including Mr. O'Connor and Mr. Flaherty, that all city staff working on this appeal for today's hearing have just simply focused on the facts and the law and are, again, have the utmost honesty and integrity driving all of their actions. Thank you.
Okay.
And my concern was simply about things like there were statements in the record about, gee, Ms. Borba had to inspect the sprinkler system, but we know that didn't happen.
Okay.
There's some things that were said in
Okay.
that I don't think came from counsel. They came from somebody else.
Okay.
And it's not Ms. Borba because Ms. Borba's gone. So.
All right. Thank you. Okay.
Just a clarification. I know we've gone over this, but I think I'd like it to be fresh in my mind anyways, so the adjusted CTL date is 11/25/19, correct? 2019. It's for staff. That's in the staff report. Pardon me? In the staff report, it says November 25th, 2019. Okay.
Can I clarify?
Not really.
I'll come back to you. I'll ask you a question in a second. So that is the staff's determination in terms of the adjusted CTL end date. And then the maximum fine of $300,000 would then therefore be reached on November 23rd, 2020.
Yes, correct.
Okay. And then we know that the building department finalized the job on December 2nd, 2020.
Yes,
And the planning department finalized the job on March 21st, 2022.
correct.
Okay, just want to make sure those dates were fresh in my mind. Thank you very much. What did you want to?
Yeah, I had mentioned before the date that and it's in the city's, I'm saying this because the city has it about 5 times in its various things. I'm quoting the city. The date that the landscaping time ran out was February 2nd, 2020. I think Ms. Cooper was correct that then you take 295 days from that, and I think you end up sometime in late November. But the date is February 2nd, 2020, from which one gets 295. Okay.
Thank you.
Okay.
Does that comment change any of the dates that we just discussed?
No, the planning department finalized it on March 21st, 2022.
And the landscaping plan doesn't
This-
affect these dates that we just discussed?
Correct.
Okay, thank you.
Can I just follow up? I'm gonna, actually, I'll skip.
Okay.
And can I just get a clarification on, from Mr. Von Son, when you did your construction pre-construction meeting with the applicant or the homeowner and one of the homeowners and the contractor. And they did not opt for the 6-month extension. Do you have documentation? Were you the only person in the meeting, or do you have some kind of documentation that they were offered and that was their response?
The meeting is recorded. We have the
Okay.
record. Yeah.
Okay, thank you.
Sorry, I now will jump back in with my question. So our code is very clear that the CTL fine stops when the planning department finals the property. And that's a bright line that we have in our ordinances. So my question there is, in terms of any other appeal that we've had from any other applicant in relation to appealing CTL fines, whilst many will claim extenuating circumstances and be looking for some relief in relation to that, has anybody ever just said, we think a different rule applies to us, and so we don't think that the planning final is the right line?
No.
Not to my knowledge, no.
Okay, thank you.
Okay, any more questions for staff?
Just one more question for clarification. Is it not in our code, our municipal code 20.04.040, that in order for a project that's been denied by the Planning Commission to come back to the Planning Commission, that it needs to have significant revisions to it before it can be heard?
We're looking. Yeah, I don't know. I don't see it in 20.04040. Do you have the
Yeah,
specifics?
20.040.A, Planning Commission may approve, conditionally approve, deny any application. Denial shall be without prejudice to a new application accompanied by substantially revised plans and a new filing fee.
Okay, yes, then it is in there.
So that would be justification not to rehear the removal of the,
But that's for denial, right?
well, we did deny the trees.
Yeah, point taken, Councilmember.
Yeah, thank you.
I guess I do have one question, and that is, it was also mentioned by Mr. O'Connor that in the 2022 resolution that it made the statement that the Tubbs fire dates were being given earlier than the way our policy reads. I think we've gone over it a couple times that our policy is that we final a project, then it goes to an appeal committee, and then relief days are recommended to the city council. Yet in that resolution, there's what appears to me to, and which was pointed out to us, be out of the normal order of the way things happen.
I don't believe I have anything else to add to that.
Okay.
What Brian previously stated in this hearing is the standard process and procedure.
The what?
What Brian spoke to earlier during the hearing is the standard process and procedure, as you described.
Okay, so you don't see that as a big red flag of any sort?
I can't speak to the 22 resolution. I don't believe I was involved in its preparation at all.
Okay. Okay, thank you. In that case, you.
I have one more question. So does that mean that the 2025 resolution supersedes the 2022 or overrides it or becomes the new resolution?
The 2022 resolution was enacted by council at that time. Certainly, since this is a further rehearing of the same matter, this resolution does effectively provide the city council's last word on the matter.
Perfect. Thank
Thank
you.
you.
Okay, thank you. Thank you. Okay, so the appellant's team has another 10 minutes if you'd like to add anything. And since you have done a lot of talking already, please don't feel that you have to. I think so. I know I am. So
There is one point.
You don't
Ms.
have to take
Wilkinson.
the whole 10 minutes.
No, I'm not going to.
Okay.
But Ms. Wilkinson talked about the bright line of the CTL. Okay. There's no doubt that the planning, you can't charge somebody with CTL past when the planning signs off. But the whole idea of the law 1442 and 302.06 is the city's policy. It's enacted in 2 laws as to when CTL fines stop running before you get to the bright line. There's no doubt you can't go past the bright line. The question is this whole law meaningless? Can someone arbitrarily, can your planning person say, you know something? I don't really like Jones. I think I'm just going to withhold the final, even though he's not doing anything. He's got landscaping construction. Maybe he isn't even doing landscaping construction. Can you just say, okay, regardless of what the law says, and you've got 2 laws here, can we ignore the law? And I say no. I think the CTL, the bright line, is an outer limit. It is not a prescriptive limit that, gee, CTL fines always run until the planning signs off on it. Well, then you might as well not have this law, because planning's always the last to sign off. And the whole idea of the law is, when do we stop CTL fines? Before there's an end to the thing. So that's what the law is about. And I think to say that this is a bright line, I think it's just plain wrong, and it's not reading the law right. It's making the law that's printed meaningless. The 2 statutes are just absolutely meaningless if you do that. The final thing I'd say is on the excessiveness. In Timms v. Indiana, Ruth Ginsburg wrote a brilliant opinion, and I'd recommend you read Timms v. Indiana. In Timms v. Indiana, the defendant transported heroin in his new pickup truck or new van. Indiana caught him, charged him with a felony. They seized, as part of it, they seized his car. Ruth Ginsburg wrote the majority, I think it was a unanimous opinion, that said this is an excessive fine under the 8th Amendment. Now, it went up 4 levels before it got to the Supreme Court. Indiana said, oh, no, truck it. No, it's not excessive. She said, look, this has been around since the Magna Carta. You can't, what they were doing with King John at Runnymede was saying, you can't just fine us because you don't like us or excessive for the harm. Now, they have cited 2 cases to you that I know you're some of your lawyers, maybe you're not.
None of us are lawyers.
There are 2 cases that they cite that are completely inapplicable. You have a fine of $663,000 in a slumlord case where he owned 4 multi-unit places, was guilty of crimes, contempt of court, and had kept people from having plumbing and heating and all kinds of niceties for 587 days. And that was a $663,000 fine. They cited another case in which a car dealer was fined $5,000 a vehicle for not having emissions standards correct, not proofing your emissions and selling things without. And the court upheld that fine as not being constitutionally excessive. We're dealing with a situation here in which $300,000, and what the reason I get into this whole idea of contempt of commission, of the fine just sitting there because the trees are sitting there until finally we get a resolution. $300,000 for this. This is something that what I'm saying is The lower courts don't give deference, or the appeals court to below. A constitutional issue is a constitutional issue, and it keeps going up, and you don't rely on the findings of a lower court as you may in another situation. So what you've got here is you've got a situation in which if this $300,000 fine stays, if we have to appeal this to the Supreme Court, we're going to do it. I mean, if you read Timms v. Indiana, I'd have to turn in my bar license if I didn't do this. This is a terrible thing. It's $300,000 for nothing. Oh gosh, well, maybe you had maybe there was a trellis someplace, but I think the trellis got withdrawn, as I said. You got two beautiful trees that beautify the area in the ground, and that's the harm. That's the $300,000 harm that this council is going to fine one of its citizens. It's in the record. He pays that they put in. He pays $141,000 a year in taxes. He's sunk $12 million into this project, and they've put in evidence that it's worth 10.5. So let me calculate this. He spent $1.5 million on taxes and permit fees, and he's down $1.5 million in value. And that's supposed to be his wealth, is supposed to be the reason you're going to fine him $300,000, which today is $400,000 with interest. That is so excessive. It shocks the conscience. It is a terrible thing we're doing here. We're supposed to be neighbors, friends, help people out, help the town, and to fine him $400,000. It's in your discretion to fine him anything you want. You don't have to accept because somebody else says this is $300,000 or $400,000. The hearing we had before, all that was said on the record was, well, it took 4.5 years. Everybody said, oh yeah, it took 4.5 years, 4.5 years, 4.5 years. Wait a second, it didn't take 4.5 years. It didn't take it. No, nobody paid any attention. Court is baffled, wants to know why this fine is issued. I would commend to your sense of fairness, to your sense of decency, that this fine get cut down to some reasonable amount. It is, and I would commend you also to even, if you need to continue this hearing, and to investigate what I said about those false facts. Those are false. I can guarantee you. There's a false facts in this record, and you should not be here to ratify them or say it's okay to give us false facts about what happened here. I'm not in any way talking about what's been told to you today. It's what's in that record. We don't know where it comes from. Didn't come from Miss Borba. She's not around. So who is saying all the stuff she did, which she didn't do? So you put this together and you say, what am I here for? To do justice, to be a public servant. We have enough. I despise James Comey, but I don't think he got fairly treated. I objected to it. I've written an article about it. You shouldn't indict James Comey for personal or political reasons. It's terrible. Our system is going downhill. And that's what's happening to my client. That's what's happening to my client right now. James Comey looks good in this case. It's not worth $300,000. I'll say that. Thank you. Appreciate it.
Okay, thank you.
I want to say something. I want to clarify. So first of all, my remodel was $4 million. I think John used a different number. That said, I think there's 7 things that really strike me, and I keep it super simple. I'm not a lawyer either. So there is no valid sunset letter. The whole case should be thrown out immediately upon that. There was no late construction under city law. 3, the only claim basis is non-tree removal. It's not construction time limit. 4, AB 1561 does apply. I've talked to the governor. He's going to agree. 5, no notice of due process was ever provided to me, so I had no idea. The city tells me there's no CTLs, and all of a sudden there is CTLs. This is so bad. To John's point, I think it's unconstitutional, and we're going to pursue it if need be. The fine is grossly excessive and will never stand. And the city's shifting stories show arbitrary and really not good judgment. And then lastly, the city lacked any legal authority to impose any CTLs on my project at all. I actually delivered the whole project myself. I literally quit my day job, came up and finished it, knowing that my contractor was in over skis. So the idea that my project's late under any scenario, not only do I not agree with, but I assure you I'll pursue this. And it really calls into question your entire CTL policy.
Okay, thank you. Okay, at this point, I'm going to close the public hearing and bring this item back to the council for deliberation. Does anybody need a break at this point? You need a break? Okay, all right. Do you want? Yeah, I think we'll just, can we come back at like 1:17? Okay. We'll reopen the meeting. So at this point, the council is, will deliberate and discuss and hopefully come up with some findings. So I just want to thank the staff for all their work on this today, and I want to thank Mr. O'Connor and Mr. Flaherty for all the work they put into this and explaining everything. From my perspective, I think the facts have been presented in a clear and understandable way in our staff report, and we've tried to understand the appellant's concerns as well. I've had the opportunity today, as have the other council members and the public, to ask clarifying questions of the staff and the appellant, and we've taken their responses into consideration. Cities have ordinances so that citizens are treated equally, are knowledgeable regarding the reasons for the ordinances, and can make reasonable personal decisions, knowing the expectations and the consequences of their actions as regards to the ordinances. From my perspective, I feel like our construction policies include both building and landscaping, as evidenced by the fact that the CTL ordinance is in Chapter 20 and not in Chapter 16. So that's kind of important to me. And I think the appellant is trying to say that one thing is construction and one thing isn't, one thing counts and one thing doesn't. But if we look at our municipal codes, which is what we use, I feel like we have to cover both and each of the requirements have to be met. So I also want to reiterate that from my perspective, I feel like I might have been quoted out of place. I don't think I said that I thought everything should go from February 2nd, 2020. I wanted to clarify that I said that the penalties were reached on April 28th, 2020. And relief dates were added after that. It seems to me that most of the issue here, and by April 28th, really did include many construction items, including unapproved other items, whether it be trees or exterior lighting on the home, or perhaps some pathways and other issues there. So I just wanted to clarify that I was using that date, not another date. I also feel that Mr. O'Connor was in his analysis is trying to change the way our policy works. And I think for me, I'm going to follow the policy that we have written down and use that going forward and not change dates and how they come up and when they come up. So that's how I'm starting out. If anyone wants to add anything.
So I also want to thank the staff for all their time that they put into this rehearing and for their patience with their guidance for me through this process. And I want to thank the applicant for all the materials and time and information that they provided. I also want to let everyone know that I did listen to the Planning Commission hearing of May and August of 2017. I re-listened to the Planning Commission meeting of August 20, 2022. And I also re-listened to the City Council appeal in July 11 of 2022. And that included reading all of the staff reports and reviewing plans if they were included in that. I also want to thank all the members of the community that attended today, shared their thoughts, and to those who wrote to us. And I also want to thank those who reached out to me personally, giving me their opinion of upholding the construction time limit as it stands, and others who asked for leniency. I can speak for myself that hearing a construction time limit appeal like this is very difficult on, I will say myself, and I'm sure it's all my fellow city council members, because it is that we do have to make a judgment on fellow community members. And that judgment includes a financial component to it. And that is something that I don't take very lightly. But I also understand that when I became a city council member, I took a pledge to uphold the laws of not only the federal government, the state government, but also our local government. And our construction time limit is part of our local municipal code, and therefore it's the law of the city. And so those are the things that I have to balance when I look at this. I try to balance everything, take everything seriously, and also try to have compassion and understanding for the appellant in their position. As I reviewed this and listened to Mr. O'Connor, some of my sticking points are that when it comes around to landscaping and not being counted as part of a construction time limit, accumulation of fine, that in our code, it says all softscape improvements, including approved plants, materials, and trees. And I think that's the one word that's missing from everything that Mr. O'Connor says is approved plants and materials. And that basically there's a design review issue with this project that was not resolved. And therefore, because we could not have a final, that a building or a planning final, that that is one reason that the construction time limit was extended to when it was finalized in March. The other thing that struck me is that he reached his maximum construction fine limit prior to the December 2, 2020 building final. And I feel that he already reached his maximum by the time we got to the building. And so getting into the whole design review, non-compliance is sort of a post fact, that he reached his maximum shortly before he even got the building final. So, I mean, that's just sort of the hurdles that I'm facing, the major hurdles I'm facing on this project.
I actually don't have much to add from what Pat just said because she was very comprehensive. I also would like to thank staff and the Mr. Flaherty's team. It's a lot of work for everybody, and I, like the rest of the council members, have taken a lot of time to really dig through everything, go back and forth with our staff to make sure that we're thinking things through and asking all the right questions and listening intently today as well to hear all of the arguments on the other side. As Pat has mentioned, we are sitting here with an obligation to uphold our code, and that means upholding our CTL penalties and treating all people that come before us equally, regardless of any, with no special treatment for anybody. And I think we try to do that very carefully with every applicant. So I cannot, our bright line, it is our planning department final. But as Pat has mentioned, Mr. Flaherty blew through the 300,000 ceiling even before the building department final. And I have not heard any compelling evidence that construction finished in any meaningful way before that building department final on December the 2nd, 2020, and his fine would already have been maxed out before then. And regardless of that, The bright line is still when the planning department final happens, and that was to a large degree under Mr. Flaherty's control as well. I don't find the argument that AB 1561 would apply here compelling at all. I think it's very clear that it doesn't. And so on the basis of that, I would agree with the 244 days of relief that the staff has recommended, but that still means full application of the $300,000 fine.
Yeah, thank you. I appreciate all of the work everybody's put into this, and I'm sorry. I wish it was a better process. I know it's incredibly painful for everybody involved to go through it, but we are where we are. As everyone else has, I spent a lot of time with all of the materials, and for me today is actually hugely helpful because there was so much material provided. I thought everything was included there, but I think the discussion today was really helpful because what it brought for me is clarity in terms of thinking about this in sort of two blocks. And the first block is really centered around when did the CTL begin, which the city, and I agree, is taking the position that it began on November 25th, 2019. When was the job first finalized from a building standpoint, which was December 2nd of 2020. However, the maximum of 300,000 was already reached by November of 2020. And so for me, that is the first chunk. And if you think about it, what comes next is sort of interesting, but it's not really as relevant in terms of the $300,000 fine. And a lot of what we discussed today and a lot of what Mr. O'Connor put forward was really about the second chunk, which is what's happened with planning and the trees and whether there was construction. But to be honest, that doesn't really have application to the first category or the first chunk of time. And so I think it's pretty clear to me that the construction time limit max was reached before we even got to a building final standpoint, even nearly before the fire department had said, yes, this building is safe to occupy. And so I feel like it's clear that that should be the penalty that is applied here. That said, I do think it's important that we read into record some of the other things that were raised, because I think those things, the things that were raised in the May 22 appeal, and actually some of the things that Mr. O'Connor had put in his November correspondence were more relevant to that first category, if you will, in terms of other things that might have had application or would require consideration around relief to the construction time limit. And so it's a little bit of a formality, but I think we're being asked to do that, so I will take a crack at it. I've reviewed the staff reports for the initial appeal hearing, today's rehearing, as well as related staff reports regarding prior design reviews. I've reviewed all of the appellant's correspondence, as well as listened to any prior city meetings regarding this project. What follows is a summary of the issues raised by the appellant in the original May 2022 appeal, as well as the supplemental correspondence submitted in November 2025. I'll walk through a summary of the key issues raised along with my findings. First, the appellant argued that landscaping required its own construction time limit, deadline, and compliance order. Under city policy, the CTL is tied to the main building permit, not to the landscape phases. The landscaping extension was already applied and no further notice was required. Given this, I agree with staff and find no reason for CTL relief on this matter. Second, the appellant cited several alleged delays beyond their control, including impacts from the 2017 Tubbs fire, heavy winter rains, neighborhood complaints, nearby lane improvements, undergrounding work, and discovery of a deteriorating retaining wall. Staff examined each of these. The full 60-day Tubbs fire extension was granted, but the remaining items either did not delay permitted work, were typical for a project of this scale, or lacked any evidence of actual scheduled impact. Therefore, I agree with staff and find no reason for CTL relief on these matters. Third, the appellant raised issues related to the Planning Commission's olive tree determination. The Planning Commission addressed the trees in its 2020 retroactive design review and required the removal or relocation. The appellant did not appeal that decision. Also, by the time this dispute was revived in 2021, the CTL penalty had already maxed out, so the tree issue had no effect on the penalty. As a result, I agree with staff and find no reason for CTL relief on this matter. Fourth, the appellant raised several legal arguments. These include the applicability of AB 1561, due process concerns, the timing of the compliance order, and claims that the fine was excessive. Staff reviewed each of these points, and I agree with their findings. AB 1561 does not apply because this was not a housing development, and the CTL had already expired before the statute's operative date. The CTL ordinance provides clear notice, which was repeated at multiple stages at the project. The compliance order was properly issued on time, and the $300,000 penalty is proportional and consistent with penalties upheld in similar regulatory cases. Finally, the appellant asked the council to consider what they described as equitable factors, the quality of the project, and the owner's contribution to the community improvements. While the city appreciates those contributions, the CTL ordinance is very clear. It requires that relief be based solely on factors outside the owner's control. So for these reasons, I agree with staff and recommend that the council deny the appeal and affirm the $300,000 penalty.
Okay, thank you. Does anyone else have any findings?
I have findings. I cannot make the finding to grant relief for any additional CTL compliance orders specific to landscaping. I can agree with the finding to grant the 90-day landscape extension. I can make the finding to grant relief credit for the tub fire of 60 days. I cannot make the finding to grant relief for weather delays. I cannot make the finding to grant relief due to appeals and complaints, which are common in this community and or took place before the building permit. I cannot make the findings to grant relief due to city contractors' work in the area for lane or the undergrounding. I cannot make the finding to grant there should be relief for refusal to reconsider the olive trees. There was no substantial revision to the olive tree per Municipal Code 20.04.040. I cannot make the findings to grant relief for nearby utility undergrounding projects. I cannot make the finding to grant further COVID-19 relief. I can not make the finding to grant relief for the underground unknown retaining wall. I cannot make the findings to grant relief for AB 1561, since it did not qualify as a housing development project as defined in AB 1561, as it added no new housing to our housing element or our arena numbers. I cannot make the findings to grant relief on prior city staff statements on the notification of AB 1561. I can make the finding to grant Marin County Shelter in Place relief of 64 days. I can make the finding to grant the city April 13, 2020 ordinance, urgency ordinance relief of 30 days. I cannot make the findings of alleged planning commissioner interference. I see no evidence of that in any document. I cannot make the findings for relief on equitable grounds as many citizens remodel and give of their time, talent, and money for the betterment of this city. Additionally, I cannot make the finding for relief on the city CTL ordinance process. It is clear from the planning application, planning commission hearing, building plans, construction management meeting, letter of compliance, and the temporary certificate of occupancy in 2019, what the CTL date was. I cannot make the finding for lack of due process based on documents and the 150-page 1126 and 12/125 declarations show that there was plenty of due process evidence in emails and documents. I cannot make the findings of excessive fines due to value, pre-construction value of 7.9, purchase price, post-construction value of 11.9, adding just the cost of the 4 million construction cost, and taking into consideration the ability to pay. I cannot make the finding of timing of compliance order. It followed our city procedure. I cannot make the finding for AB 1561 extension. Does not meet the definition of a housing development project, adding to our housing element and marina number. Yeah, that's it. I'm done. Thank you.
Okay. You have anything to add?
No, I'm not going to add to the time taken here. I would fully concur with all of the comments that Councilmember Carapia has made in terms of findings. Thank you.
Okay, for the purposes of this hearing and knowing that Judge Sweet has requested clear findings, I'll go through each of the appellant's arguments as well. For the lack of an issuance of a CTL compliance order for landscape scope work, our ordinances do not allow for that, and all permits fall under the same day. However, I do support the 90 days of relief for landscaping purposes. I agree and support the staff's recommendation of 60 days for the Tubbs fire. As far as usually heavy winter weather, the permit for exterior improvements was not approved until February 6, 2019, and exterior work wouldn't have begun until after that date. I'm assuming that prior to this, interior work was occurring and the weather should have had a little impact on that. As we all know, rainfall in Belvedere is much less than where it's measured in Marin County, which is at the base of Mount Tam, which gets a lot more water than we do. And in reviewing the building permits, I noted that there were 14 encroachment permits and a retaining wall replacement exemption requested from December 2018 through March 2019. 4 of those encroachment permits were for concrete pours, which I imagine would be difficult if we had terrible rain. And for these reasons, I don't support additional relief days. We heard today that any appeals or complaints didn't seem to have any delay on the project. Therefore, I don't support relief days for this reason. We were also told by the appellant that, or I think alluded to, that the adjacent lane and undergrounding district didn't cause any delays. Everybody was getting along and it seemed to be fine. So I don't see any reason to add relief days if there were no delays caused. Denial of the olive tree determination appealed by the Planning Commission. In our code, appeals have stated timelines. An appeal of the Planning Commission's August 2020 conditions of approval needed to be filed within 10 days, and it was not. In March 2021, when the Planning Commission meeting was scheduled, as well after the penalty had already been reached in April, nearly a year before. I think we all agree that administrative approval was given for the 3 trees in the rear, so there wouldn't have been any reason to have a meeting for that. And therefore, staff pulled the item off of that. So I agree that no relief days could have caused, and there were no delays due to this, and therefore relief days I don't support giving. Undergrounding, I think we discussed that one already, but apparently it didn't cause any delays, so I don't see any reason for days there. I do support the 64 days for the COVID from our city. As far as the underground retaining wall, we heard that didn't cause any delays, so I don't support relief days for that. Not being awarded the AB 1561. Again, I will agree that this did not add any housing stock to the city, and that this statute came in under housing element law for the state and was directly geared toward housing developments. So I don't find any relief for that reason. As far as the staff awarding, as giving notice that they would award it, I don't believe the staff has the authority to waive penalties or any application of our ordinances. I don't know if this was mentioned by the staff member as a possibility or stated as a promise, but in any case, only the city council has the authority to reduce fees assessed under the CTL ordinance. And that didn't happen until July 2022 at the appeal hearing. So I know it was unfortunate that the call occurred, but I find no relief days should be granted since the project doesn't meet the requirements of this statute. I support the county ordered relief days and the urgency CTL relief days given. As far as interference by a planning commissioner, I feel that I addressed that earlier, that was handled by the planning chair, pulling it from the March meeting, in which case, anyway, the applicant had a chance, or appellant had a chance to appeal and chose not to. As far as equitable considerations, I think the point of our policies and ordinances is to ensure as much as possible that Belvedere residents are treated equally and not subject to individual subjective opinions. I don't feel that anything was hidden or confusing. I feel, in fact, that Mr. Flaherty was shown deference by the staff. There were no stop work orders for unapproved work. They complied with the request of the temporary certificate of occupancy so that the family could move in. There was an offer of 1561 days, even though it was in error. There was an offer of returning to the Planning Commission in an attempt to appeal a previous decision, even though that was contrary to our policy. I listened to the August 2020 Planning Commission meeting, as I said, and heard commissioners struggle with how to address the unpermitted actions taken by Mr. Flaherty. They tried to make as few conditions as possible, but the ones they made created a standard that had to be met. And I read in the emails that the city manager at the time worked closely with you, as you mentioned, to try to get to a mutually agreeable solution here. Therefore, I don't see that any relief days should be given for that. On the operation of the city's CTL ordinance and regulation of construction activity, I agree with the staff analysis that the ordinance was clear, dates were visible on many documents. The appellant signed the temporary certificate of occupancy notification letter that stated the process. As answered in the question when asked, construction is not defined simply by hammer and nails. There are approvals from both building and planning that delineate when the project can be final, and conflating the ordinance with a simplistic version of what construction is just isn't sustainable for the city. I find that there were significant and numerous late design changes leading to delays. For example, the 28 separate permits for concrete pours. And therefore, I find no additional relief days. As far as lack of due process, I believe our staff conveys information on the entire permitting and building process. Not only is there comprehensive pre-construction meeting, but permit expiration dates appear on many documents, permits, letters. You requested and received 12 planning department exceptions, and a design review in front of the planning commission. You heard the conditions at the August 2020 meeting, and you chose not to appeal those conditions, therefore meaning that you were willing to comply with them. In fact, at the meeting, Mr. Flaherty did say, we're happy to accommodate. We will clearly comply. At this point, you already knew the CTL penalty was occurring, and perhaps it didn't matter because you already passed it. And so you were just continuing on. I don't really know. But in any case, I don't think that due process was a problem here. As far as an excessive fine, I actually did read Tim's case, and it was focused on an asset of forfeiture, which is an especially difficult situation for poorer people, as they may need that asset to survive. This remodel project had a valuation of $4 million. And although a lot of money, the $300,000 penalty should not have an economic effect on the owner. The penalty amount should not be a hardship for Mr. Flaherty. He had full knowledge of the CTL ordinance. He was told multiple times how impactful change orders would be to the project. He made his own decisions. We're following our code and not demanding more than what was allowed. And in 2022, per the 11th Circuit U.S. Appeals case that I read, they allow fines to be compounded over time, which is what occurred in our case here. The timing of a compliance order. The relief days and the CTL days are what count, and that's what we have to go by. The city's process is to offer the appeal committee, as we noted many times. And I won't belabor that. Project should have received an extension under AB 1561. I think we dealt with that, and I don't see any relief days should be owed there. So I guess I would just say that on the surface, this does appear to be a very complex problem, and the appellant and his attorney are presenting it that way. Many of us here today were not involved with this project and must rely on all the evidence before us. I actually believe this is a simple problem. An 18-month permit was issued with an expiration date of May 28. A 1-month grace period was granted to finish. The project was not completed by June 29th, 2019. Notification was given that penalties would begin. Daily penalties accrued for 10 months, taking it to April 28, 2020, when the maximum was reached. There was no additional increase of any fines after that date. What happened after April 28th through to March 2022 had no impact on the change of that amount. This is a penalty on a remodel, not about olive trees. So, Andrew, I have a question. Do we take a motion at this point? Do I ask for a motion?
Yes, you can. And Mayor, I can propose a motion if you desire.
But I wanted to
Please.
ask you, when do we talk about the resolution? After
The draft resolution in the
Yeah.
packet. Certainly, if you have any additions or requests with respect to the draft resolution, this would be an appropriate time.
before we take the vote? Or
Well,
after?
Yeah, so let me suggest my proposed
Okay.
motion, and then you can let me know if we need to tweak that at all. So from what I've heard so far up on the dais, I think the proposed motion could be move to deny the appeal and to oppose a CTL penalty of $300,000 on 339 Golden Gate Avenue and its owners. This determination is based upon the findings stated by council at this rehearing, findings drafted by staff in the proposed resolution, recommendations made in the staff report, and additional materials and statements provided at today's hearing.
Okay,
I believe that would be satisfactory, but if you do want to provide more detailed guidance on the draft resolution, that would certainly be appropriate as well.
well, I still have a question about the resolution.
Of course.
So if we wanted to add or had a question about the resolution, do we do that before we take our motion vote or after?
Yeah, I think we should do that now. If there's specific feedback
Okay.
you want to provide on the draft resolution, this would be an appropriate time.
Okay, so Councilmember Carapia.
So on item 5, and item 5F, it says reach the maximum 300,000 penalty by November 30th, 2020. Shouldn't that be November 23rd, 2020? Do I have my dates wrong? I might kind of brain dead.
I'm brain dead too. I don't even know where the resolution is anymore.
Mhm. I mean, it's a technicality, but I mean, can you check it and then make sure it's right?
Yeah, so this is the date when there's a maximum penalty. Yeah, I believe Councilmember Carapet, I believe it is November 23rd.
Okay, then the only other one I have is on 5M as in Mary. The city April 13, 2020 urgency ordinance, I should be reading 2020.
I'm sorry, someone just closed the door when you mentioned which
No,
item
it's like
number is it again?
M as in Mary. So it says city's April 13, 2020 urgency ordinance. I think it was in 2020.
Yes,
COVID.
thank
Yeah.
you.
And then, let me flip the page, and that was it. And then the only other thing is in the whereas on June 20th, June 21st, 2020, it's the second paragraph on page 2, that whereas. It says the planning commission approved these project revisions. I think it should also contain with conditions, because otherwise it looks like we just approved everything, but we did have those conditions. And then the only other is in the next paragraph, whereas on December 2nd, 2020. Oh, no, never mind. I take that back. That's the only one. I just think that, I mean, we approved the retroactive design review, but it was done with conditions. So I think it should say approved with conditions.
Yeah, understood.
Yeah.
Very
That's
fair
it.
point. Thank you, Councilmember.
That's it.
Does anyone else have any comments about the resolution?
No, I mean, just adding to Pat's question about the date in the staff report, it also says November the 30th. So I think, but I know in an email you'd given a different date. So just clarify that to be exact.
Yeah, we will confirm that as November 23rd.
Okay.
Thank you.
I was just wondering if it would be appropriate to add a whereas at the bottom of the first page, I guess is where it would come chronologically. Nope. No, it would come after the first whereas on page 2, which says, whereas on March 31, 2020, County of Marin issued a pandemic. And what I wanted to add was, whereas on April 28th, 2020, the maximum penalty of 300,000 was reached and no other penalty accrued after that date, if you think that's appropriate.
I'm sorry, could you read that again?
Whereas on April 28th, 2020, the maximum penalty of 300,000 was reached. That's with the relief days. But
I think that gets confusing
Okay,
when you don't
okay, then
use-
let's not
yeah,
bother.
yeah.
Okay, forget it.
I mean, we
Okay.
have one date and I think it should be that.
Keep the one
November-
date.
Yeah.
Okay.
Okay, thank you.
Yeah, no,
And I'm sorry, Mayor, any other
no, no,
edits?
no. That's it.
Yes, Scott Sullivan.
Okay, so then can I have a motion to,
If you want me to restate it, I'm happy to. Okay. Move to deny the appeal and to oppose a CTL penalty of $300,000 on 339 Golden Gate Avenue and its owners. This determination is based upon the findings stated by council at this rehearing, findings drafted by staff in the proposed resolutions as modified, recommendations made in the staff report, and additional materials and statements provided at today's hearing.
Second. Did anyone move it?
wait, she has to.
I-
Oh, you
I
move
don't
it.
count as the
Second,
mover.
yeah, forget, yeah, move it.
So moved.
Second.
All in favor? Aye.
Slow.
Long.
Have to say aye. Say aye.
Aye.
Oh, thank you. And just for the record, of course, that was 4 ayes.
Correct.
Thank you.
Does this come back?
I think the resolution will be returned in January.
Yes,
Is
to
that
make-
correct?
That is correct. To make sure that absolutely everything is covered and it is complete, it will be returned to council as a consent item at the January regular meeting.
Okay, okay, thank you. In that case, I'll close the meeting of December 3rd.